aspect. In future, we shall reduce it. We shall reduce it. In fact, we shall reduce it. Yes, sir. You know, let me start the meeting now. It's already 2 minutes past. I welcome all the participants, especially Geeta ji, our learned speaker, Mr. Madan, Mr. Nipun Singhvi ji, my co-host, Mr. Nilesh Sharma ji, Mr. Ashwini Mehra, Mr. Rajkumar, Mr. Puneet, Mr. Kapil Taneja. Kapil ji is also there, very senior member, and Mr. Subodh Gokhale ji. And as you are aware, the words of message have been circulated to all. The topic for today's discussion, I should say, it is very, very hot. In terms of IPs. मदन सर स्माइल कर रहे हैं, निपुण जी भी स्माइल कर रहे हैं. तो सर मैं तो इस पूरे सेशन के अंदर आईपीएस की तरफ से बोलूंगा, बट यू नो जस्ट टू मेंटेन बैलेंस एज अ स्पीकर आप जैसा आप कहेंगे ठीक बात है. तो डिस्कशन का जो आज का टॉपिक है, डिस्कशन ऑन डीसी रिसेंट डीसी आईबीबीआई केसेस अगेंस्ट आईपीएस एंड रेमेडियल एक्शन अगेंस्ट दैट. सर स्टार्ट करने से पहले मैं ना एक बड़ी छोटी सी बात याद करना चाहूंगा. सिंस वी आई एम चार्टर्ड अकाउंटेंट, आई एम फ्रॉम द टैक्स प्रैक्टिशनर साइड ऑफ. हमारे यहाँ पे ना दो बड़े इंपॉर्टेंट केसेस हुए हैं पिछले 1-2 महीने के अंदर, विच एवरीबॉडी ऑफ अस मस्ट बी अवेयर. एक तो वोडाफोन का केस, खैर वो तो 1.5-2 साल पुरानी बात है, हो गया था. वोडाफोन के केस में क्या हुआ था, दिल्ली हाई कोर्ट ने कहा जी नो, सुप्रीम कोर्ट ने कहा यस, सेंट्रल गवर्नमेंट ने सॉरी दिल्ली हाई कोर्ट ने कहा यस, सुप्रीम कोर्ट ने कहा नो. सेंट्रल गवर्नमेंट ब्रॉट सम प्रोमोगेशन एंड मेड इट कन्वर्टेड इनटू यस एंड मेड द इनकम टैक्सेबल. उसके बाद यू नो वोडाफोन पीपल वेंट टू द you know international court of arbitration or justice and they also revoked the decision. Ultimately they did not pay the taxes. दूसरा, अभी 1-2 महीने पहले हमारे यहाँ पे एक यू नो देयर वाज 2 साल पहले बजट के अंदर 148 सेक्शन 147 की नई एक कंट्रोवर्सी राइज हुई थी. एक्सेप्ट 2 हाई कोर्ट्स, ऑल द हाई कोर्ट्स वेंट इन फेवर ऑफ द एसएससी, बट यू नो जो 2 हाई कोर्ट्स नॉन फेवर में गई थी, सुप्रीम कोर्ट अल्टीमेटली सब सारी पिटिशंस को उन्होंने क्लब करके दे कंक्लूडेड द डिसीजन एंड दे सेड कि गवर्नमेंट ने जो ये सेक्शन लाया, जो प्रोसीजर लैप्स है इसके अंदर, इट शुड बी यू नो एसेसर्स आर मेड लायबल टू पे टैक्सेस अगेंस्ट इट. मीनिंग देयर बाय कि जब इतने लर्नड अथॉरिटीज, इतनी लर्नड यू नो जुडिशरी पर्सन और इतना हमारा पुराना लॉ, इनकम टैक्स एक्ट 1961 का नहीं है, ये 1927 का है, उसके अंदर इंटरप्रिटेशन करने में इतनी दिक्कत आ जाती है, और उसके बाद एक पर्टिकुलर अथॉरिटी दे डोंट सेटल विद ईच अदर एंड अल्टीमेटली द ऑनरेबल सुप्रीम कोर्ट अनसेटल द होल थिंग. अगर हम 147 148 की लॉ को करें तो सुप्रीम कोर्ट फर्स्ट टाइम इन द हिस्ट्री ऑफ इनकम टैक्स इन्वोक्ड देयर power under section 142 and came out with the conclusion कि these are the procedural lapses and these notice should be held valid. तो हम जब आईपी काम करते हैं, जिनके पास ना तो इतनी इंफ्रास्ट्रक्चर है और ना ही उनके पास शायद यू नो इतनी स्ट्रेंथ है जुडिशली, और मेनी अ टाइम्स ऐसा होता है कि कहते हैं ना जैसे सीओसी की कमर्शियल विजडम है, वी आल्सो वर्क विद कमर्शियल विजडम यू नो टेकिंग डिसीजन. यानी कि कहने का मतलब यह है कि मेनी अ टाइम्स कमर्शियल विजडम क्या होता है कि हमारे को शॉर्ट टर्म लॉसेस को छोड़ के हम जो एक लॉन्ग टर्म गोल है, जैसे वैल्यू मैक्सिमाइजेशन कह लो या टाइम लाइन कह लो, उसको अचीव करने के लिए if we you know commit some mistake, या if we willingly or most of the time it is unwittingly, none of the IP, because एक मैंने पहले भी कहा था, सबसे बड़ी बात आप ये देखिए, let's talk about the status of an average IP. हमारे यहाँ पे 3,500-4,000 के करीब आईपीज हैं, हार्डली उनमें से 500 के करीब आईपीज को काम मिलता है, और जो बाकी 3,000 आईपीज हैं, दे आर ऑलवेज स्ट्राइव फॉर द वर्क, दे आर ऑलवेज एक्साइटेड कि हमारे को 1 या 2 असाइनमेंट मिले, सो दैट यू नो हमने जो एग्जाम क्लियर करा है, जो हम एक 50 ईयर्स की एज के आसपास आके हम अपने आप को एक नई चीज के अंदर हमने अपना सिर क्या कहते हैं ओखली में डाला, तो वी शुड हैव समथिंग फ्रॉम दैट. तो वी व्हाट आई मीन टू से इज दैट ये मेरी पूरी बैकग्राउंड बनाने का पर्पस ये है कि वी नेवर हैव एनी अनइंटेंडिंग थिंग्स टू गो फॉर इट. डिस्पाइट ऑल दिस थिंग, आवर बिग ब्रदर IBBI, विद ग्रेट रिस्पेक्ट, विद ग्रेट ऑनर टू देम, कि अगर हमारे से ये देखा गया, सर अभी हमारे मदान सर और निपुण जी इसको थोड़ा सा डिटेल में कहेंगे, बताएंगे हमारे को, कि अगर हमारे से कोई क्या कहते हैं होनी अनहोनी में कोई गलती हो जाती है, तो वी आर बीइंग पेनलाइज्ड वेरी हेवी. अब एक बात देखिए, 50-55 साल, जैसे हम लोग इफ यू सी द फेसेस ऑफ मोस्ट ऑफ द पीपल हियर, वी बी अराउंड 50-55 इयर्स ऑफ एज। इस एज में आके अगर हमारी वर्दी के ऊपर कोई दाग लग जाता है, फिर हमारे ऊपर कुछ इस तरह का दाग लग जाता है, वेयर बाय सस्पेंशन ऑफ 1 मंथ, 2 मंथ, 3 मंथ, इट्स समथिंग अनकॉल्ड फॉर, दिस समथिंग अनकॉल्ड फॉर, और रिस्पेक्टफुली वी हैव टू फॉलो इट अप, और वी शैल स्टार्ट विद इट। तो सर, स्पीकर सर, मेरे आपसे मैंने 3 या 4 क्वेश्चन प्रिपेयर करे हैं, तो जैसे ही डेलिब्रेशन हमारी होगी तो प्लीज इनको जरा ले लेना। जैसे कि मैंने एक पहला क्वेश्चन तो मेरा यही था कि इवन जुडिशियल अथॉरिटीज हैव इंटरप्रिटेशन इश्यूज मोस्ट ऑफ द टाइम। चीजें आती हैं, फिर रिवर्स हो जाती हैं, फिर आती हैं, फिर रिवर्स हो जाती हैं। अल्टीमेटली गवर्नमेंट हैव टू गो टू द पार्लियामेंट एंड रेक्टिफाई ऑल दोस सुप्रीम कोर्ट ऑर्डर्स एंड अदर थिंग्स आल्सो। दूसरा मेरा ये है इसके अंदर, व्हाट आर द रियल प्लॉजिबल रीजंस फॉर हार्श ऑर्डर्स बाय डीसी अगेंस्ट नेग्लिजिबल ऑर्डर्स अगेंस्ट द पर्सन। यानी कि व्हाट आई मीन टू से इज दैट कि अगर हम देखिए, हमारे पास अगर जैसे मैं सीए हूं, तो मेरे को इंस्टीट्यूट ऑफ चार्टर्ड अकाउंटेंट भी गवर्न करती है, नंबर 1। मुकेश जी, आई वेलकम यू, प्लीज वेलकम, अपने आपको अनम्यूट कर लीजिए, प्लीज वेलकम, आई वेलकम यू, नमस्कार।
थैंक यू सर, थैंक यू वेरी मच।
ओके, तो कहने का मतलब ये है कि जैसे अगर हमारे को हमारी इंस्टीट्यूट चार्टर्ड अकाउंटेंट ऑफ इंडिया हमारे को अगर गवर्न करती है, तो अगर हम वहां पर डिसिप्लिनरी केसेस देखें और उनका कंपैरिजन करें हम अपने ये आईबीबीआई के केसेस साथ, तो यहाँ पे अगर 15-20% केसेस डिसिप्लिनरी जाता है, वहां पे हार्डली 0.00001% केसेस जाते हैं। दूसरा क्वेश्चन सर, मेरी रिक्वेस्ट आपसे, तीसरी इनफैक्ट रिक्वेस्ट ये है कि डीसी जो प्रोसीजर फॉलो करता है हमारे को पैनलाइज करने के लिए, डिसीजन मेकिंग के लिए, is that particular process is being followed with letter and spirit, or simply decision taken with pre-notion? Sir smile कर रहे हैं, got half answer. तीसरी सर मेरा, सॉरी, चौथा क्वेश्चन मेरा ये है कि व्हाई जो हम लोग सफरर हैं, जो आईपी सफरर हैं बिकॉज ऑफ डीसी, व्हाई दे आर नॉट, दे डोंट गो टू द हाई कोर्ट, दे डोंट गो टू द हायर अथॉरिटी फॉर एज फार एज एपलेट पर्पस, फॉर फाइलिंग अपील अगेंस्ट दैट। पांचवा मेरा सर इसके अंदर ये है कि एज वी नो, एनसीएलटी और एनसीएलएटी हैज नो पावर टू एडजुडिकेट दीस टाइप ऑफ डिसीजंस। I feel, we demand, in fact, I feel that we demand that this IBC, sorry, NCLT is a platform which knows the best कि IBC के अंदर practically क्या difficulties आ रही हैं, और they know the best as far as IBC is concerned. Why the power is not, statute did not think of granting power to them for all these cases. Sir, एक मेरा यानी कि एक मेरा क्वेश्चन ये भी है, 2 क्वेश्चन पर मेरे हो रहे हैं, by penalizing like this, is our fundamental right under Article 32 of the Constitution of work, which gives us a right to work, is not that being violated? और लास्ट में सर मैं आपसे ये क्वेश्चन और करूंगा, मेरे को ये थोड़ा सा लगता है, दिस इज माय थॉट प्रोसेस, कि इज देयर नॉट ए कन्फ्लिक्टिंग सिचुएशन? आईबीबीआई हमारे से फीस चार्ज करता है, परसेंटेज बेसिस पे फीस चार्ज करता है हमारी फीस के अगेंस्ट। अब एक नया डिस्कशन पेपर आया था जिसके अंदर 2-3 एलिमेंट्स ऑफ चार्जिंग फीस इज आर बीइंग एडेड। एक तरह से तो हमारे से फीस ले रहे हैं फॉर रनिंग देयर, इफ वी सी देयर पेपर, तो डिस्कशन पेपर का प्रीएम्बल यही था कि हमारे इतने खर्चे हो रहे हैं, हम इनको मीट आउट नहीं कर पा रहे, दैट इज व्हाई वी आर इंक्रीजिंग आवर फीस, ईदर फ्रॉम अस और फ्रॉम द आईई और फ्रॉम सम अदर स्टैट्यूटरी अथॉरिटीज। इज नॉट ए कॉन्फ्लिक्ट ऑफ इंटरेस्ट? लास्ट में सर मेरा क्वेश्चन ये है, जब इतने सारे वो कहते हैं ना हम बोझ डाल देंगे आईपीएस के ऊपर, और स्पेशली टू दोज एक्सपीरियंस आईपीएस, डोंट यू फील दैट नन ऑफ द गुड स्किल्ड पर्सन विल एवर थॉट ऑफ डूइंग द आईपी वर्क if things go on moving like this? Sir, this was my only humble submission. Now we all are waiting to listen to Madan ji and Nipun ji. तो सर ये मेरी छोटी सी थोड़ी सी गुजारिश थी जो आईपी फ्रेटर्निटी की तरफ से थी। मेरे कुछ यानी कि लिसनर्स या मेरे कोर्स जो हैं, if they want to say something, please add to what I said, and then Madan sir or Nipun ji will have the baton and they will do everything. The moment Mamta ji joins us, she will take chair from me. Sir, Madan sir, Nipun ji unmute कर लीजिए अपने आप को please. Yes. No, yes.
आपने अपनी लिबर्टी दिया बाकी पार्टिसिपेंट्स को, whether they want to speak or should we start?
Sir, if they want to add something what I said, तो ये प्लीज ऐड सर। मुकेश सर, आपने अपने आप को अनम्यूट करा, प्लीज आप कुछ ऐड करिए जो मैंने कहा उसके साथ।
नहीं ठीक है सर, आपने सब कुछ काफी कुछ कवर कर लिया है। तो लेट अस लिसन टू मदान साहब। नमस्कार सर, क्या हाल है भाई साहब?
मुकेश जी, पहले तो मैं ये जानना चाहूंगा कि हम सब वी गाइस आर एजिंग डे बाय डे, बट यू आर गेटिंग यंगर डे बाय डे. व्हाट इज द सीक्रेट ऑफ दिस?
बिकॉज आई एम नॉट एन आरपी ना।
सर इससे अच्छा सर आप नहीं दे सकते थे। ये
I
आई
should
एम
give
रियली
it.
हैप्पी।
Yes, Manoj ji, can we start now?
Sir,
Whether
please,
Nikunj is
please.
going to take the lead or I should take the lead? Yeah, please.
Sir, as tradition demands, Madan sir will take the lead.
Thank you. Good afternoon, everybody. And my thanks to the association led by Mr. Manoj Kumar Anand for giving me this opportunity. And I hope I have been given this opportunity to open my heart and not to conserve my views. And I also request all the serious participants, if you can open their videos. I would like to see the faces also when we speak. I want to see the face reactions also. And it will be possible for them to raise their hands also during the discussion, because I want it to be a round table rather than having some sort of a one-way speech or lecture. या अभी भी बहुत लिमिटेड लोगों ने ऑन किया है। कपिल जी, आप कहाँ पर हो? संजीव आहूजा जी ने भी अभी ज्वाइन किया था, बट आई डोंट नो ही इज।
कपिल जी नमस्कार।
पहले तो मेरी मनोज जी आपको बधाई हो कि आपने ये टॉपिक, आई थिंक दिस आई एम सीइंग दिस टॉपिक फर्स्ट टाइम इन द एंटायर कंट्री व्हेन वी आर हैविंग ए वेबिनार, एंड आई थिंक द रीसेंट orders of IBBI has motivated, these orders have motivated you that such type of webinars, or in our webinars, in our interaction meeting, we should have such discussions, because this is now concerning all of us and this is serious concern. You said it very rightly ki all of us are within the range of 50-55 years, some around 60-65 also. We are having 20 to 30 to 40 years of practical experience exposure on our back. And one fine morning, we find an order on the IBBI website that Mr. So-and-so is suspended for so many years. And whatever fee has been received, a part of that fee he has to deposit with IBBI or within a particular fund. And then you will not continue to work as RP also. I'll come to this. This is the last portion of the order, which was there earlier and which is now. I remember on 10th of June 2022, that is last month only, in this 75th year of India independence, when IBBI was holding its event at India Habitat Center, I heard IBBI chairperson saying that this law is at nascent stage. After the expiry of 5.5 years, IBBI chairperson himself said the law is at nascent stage. But I find in practical life, this law is at nascent stage for all the stakeholders except but the insolvency professionals. This law is on nascent stage for him. He is supposed to be an expert in everything, in law, in technology, in governance, in management, in dealing with all the stakeholders. A company which was badly managed by the erstwhile management, the directors could not handle it. The company has become defaulter with almost all the stakeholders, all the creditors. Now this insolvency professional is expected to do wonders in the company, to keep the company as a going concern, to bring the profits, to keep able to do all the compliances. The compliances have not been there for years together. But now this insolvency professional is expected to do all the compliances. And if it doesn't do that, he is held guilty. And then who is holding us guilty? Our own regulator, our own guardian, our own parents, the Insolvency Professional Agency, Insolvency and Bankruptcy Board of India. During last couple of months, friends, you must have seen a video on WhatsApp that is somewhere in Coimbatore. There's a herd of elephants is crossing the road and one baby elephant is there in between. But all those major elephants are protecting this baby elephant. When I saw that video, I considered this baby elephant to be insolvency professional. And all those senior major elephants to be our regulators and the government of India and all that. But there the baby elephant was being protected, and here the baby elephant is being punished for no fault of his. There are certain reasons, there might be certain cases where the insolvency professionals have committed some mistakes. And Manoj ji, आपने बहुत अच्छा word use किया, जाने अनजाने कोई होनी अनहोनी हो जाती है. You use these words. That's possible. Sometimes we are not intending, but we have not complied with some law. And sometimes we are supposed to comply with all the provisions of the code. And if we comply try to comply with all the provisions of the code, किसी ना किसी एक की violation हो जाएगी. And there are certain numerous examples in recent DC orders which I myself have handled. I pleaded before the disciplinary committee that these mistakes, these non-compliances are bound to happen. You cannot punish an insolvency professional for this. But there they do not listen to, they do not hear. The disciplinary committee just sits like this, will not speak anything, will just listen to you, and you are not sure whether they are hearing you or not and what shall be the outcome of the case. They just don't ask you any question, the disciplinary committee. Now, before I come to the practical case studies, what is happening, why the disciplinary cases are happening, why these punishments are being made, why show cause notices are being issued. First of all, an insolvency professional is considered to be a Bhagwan. He's a god. He cannot commit any mistake and he has to please everybody. And while in reality, that he cannot please anybody. None of the stakeholders is happy with him. And particularly in real estate cases. Therefore, these stakeholders, so-called financial creditors, in some cases operational creditors, in some cases directors of the corporate debtor, in some cases COC members, and last but not the least, the unsuccessful resolution applicants. They tend to file complaints against this insolvency professional. Sometimes there are anonymous complaints. And why these anonymous complaints are being filed? Because everybody knows once we file a complaint, IBBI will put this insolvency professional to a task. Because this complaint as it is, without disclosing the name of the complainant, shall be forwarded to the insolvency professional, and he shall be asked to give a reply to this within 7 days, 10 days or 14 days, para-wise reply with all proofs and evidence in support of his reply. The complainant is not asked to justify his complaint, to give proof in support of his complaint, but it is the insolvency professional who is asked to give reply, to give evidences in support of his complaint, in support of his reply. Okay, now he gives the reply. IBBI invariably will not be satisfied with this reply. Now you will receive an inspection notice. Once you receive the inspection notice, inspection will be conducted. You will be submitting all your documents, reports. There's a long list. Almost whatever you have done till date, every document shall be submitted to them, even though that is available on IBBI portal. But still you will be asked to submit each copy of all those documents. Okay. Now, after all this, then you shall be submitted a draft inspection report. and where certain observations will be there, though they use the word observations, but I call them allegations. Now you need to reply to this draft inspection report. Once the draft inspection report is replied, after this reply, as per the law, somebody is writing, where should the, Manoj, you can take care of the comments or in the chat box. Now, once this reply is filed, now board prepares a final inspection report. Or rather, I'll say this, inspecting agency. And board also uses the two terms, inspection agency or investigation agency. These two terms are being used invariably. In short, it's called IA. Now this IA prepares a final report. And this final report is submitted to the board. Here I fail to understand what sort of provision is this. Who is there in IA? Are there not employees of IA board? And then we are saying the IA is submitting, IA has been constituted by the board. The IA is doing the inspection. IA is issuing draft inspection report. IA is receiving the reply. After receipt of the reply, now IA is submitting a final report to whom? To the board. It means I am submitting a report to me only. Now, once this report is submitted to the board, then the board considers whether this matter should be referred to DC or not. And invariably, this matter shall be referred to DC. Before this matter is referred to DC, you shall be issued a show cause notice. Now, on this show cause notice, you have again got a liberty to file a reply. In number of cases, I have raised this objection the moment I receive a show cause notice, because the show cause notice is on the basis of the final inspection report. And if show cause notice is issued to me, there is a final inspection report against me, legally I have a right to have a copy of that final inspection report. But unfortunately, this final inspection report is never shared with me. You are issuing me a show cause notice on the basis of a report which is not there with me. And then you say reply to the show cause notice. I ask this final inspection report, I will never receive it, but I have no other discretion but to file a reply to SCN. Because if I don't file a reply, without filing a reply, action will be taken against me and one more allegation will be against me. I have not cooperated the board. So I'll be punished for that also. Okay. Now final inspection report is there. My reply is there. And in reply, I always write that I seek an opportunity of getting a personal hearing before the disciplinary committee. Now a disciplinary committee hearing will be there. They are, I can represent myself alone or through my lawyer, or both of us can be there. Now in this, after the disciplinary committee, again, if I so desire, I get a right to file a brief written submission on the basis of whatever have been my submission before the disciplinary committee. And there may be a possibility that disciplinary committee is also asking me certain questions or asking me for certain documents during this disciplinary hearing. I am given that right also, and once I give the written submission, then certainly after that an order is passed. Now this order which is being passed and which was being passed, what is the difference between the two orders? Earlier, the DC order was saying that Mr. So and so shall not seek any fresh assignment for a period of next 1 year. However, during this period of 1 year, he is directed, the word is directed. He is directed that he shall continue with all his existing assignments. The suspension word was not there earlier. He shall not take up any fresh assignment. So that was the only embargo. And all existing assignments, he is duty bound to complete all those existing assignments. But the orders which are being passed now, it is said there that Mr. So and so is his registration is suspended. The registration of Mr. So and so is suspended for a period of 3 years. It's not that I'll not take up any fresh assignment. My registration is suspended. Okay. Then it said, a copy of this order shall be forwarded to the committee of creditors of this particular corporate debtor in respect of which this action is being taken. But order is not clear that who shall send a copy of the disciplinary order. It says the copy of this order shall be sent, shall be forwarded by whom? Whether by IBBI or by the insolvency professional. No clarity. Second, a copy of this order shall also be sent to all the committee of creditors of all the corporate debtors where this insolvency professional is acting as a RP or IRP. And now the COCs of these corporate debtors, the subject corporate debtor and other corporate debtors, they may decide whether to continue with my services or to discontinue with my services. And if they decide to discontinue with my services, they are at liberty to file an application before adjudicating authority. Now, this is the scenario. There is a suspension. Order shall be sent to the COC and COC now can decide. But invariably, there is a particular provision in the order, particular statement in the order, that this order shall come into effect after 30 days from the date of this order. It means during this 30 days period, this order is not effective. According to why this 30 days period is given, so that during this 30 days, if this order is required to be challenged, or if the IP is of the opinion that the order should be challenged, he can challenge this order. But where are the challenging provisions? The whole IBC is silent. There is no appellate authority. There is no appeal provision. I'm really surprised, rather shocked to see that a disciplinary action can be taken against insolvency professional without having any appellate provision. Where should I go? What can I do during this 30 days? So the only option lies before this insolvency professional is to file a writ petition, to prefer a writ petition before the respective High Court. Now, why I'm saying the respective High Court? This writ petition can be preferred only at High Court of Delhi because IBBI office is in Delhi, or at a particular High Court in which, or the state, wherever this High Court is having the jurisdiction, if the insolvency professional is having his official address in that particular city or state. Like recently, we have seen two of the insolvency professionals who registered office there in Ludhiana. They have preferred a writ petition before Punjab and Haryana High Court at Chandigarh. And fortunately, both of them got a suspension of this order of the disciplinary committee. Now, before I come to those orders, my submission is, this is entire disciplinary process or provisions of the code are having total flaws. Principles of natural justice are not followed at all. Copy of the final inspection report is not served to the insolvency professional. Secondly, you are talking about a disciplinary committee, which is a quasi-judicial body. And this body is taking quasi-criminal punishment. You are suspending. You are levying a heavy penalty. But who is there in DC? The provision says the disciplinary committee of the board shall consist of whole-time members. So these whole-time members are also from the board. Now see this entire process in toto. There is an inspecting authority constituted by the board. This authority submits its final report to the board. The board sends this matter to the disciplinary committee, and disciplinary committee shall consist of whole-time members of the board. ये तो सारा इन-हाउस मैकेनिज्म हो गया। वो सुनते थे ना पहले कि कभी Sonia Gandhi submitted her resignation to Sonia Gandhi and Sonia Gandhi rejected the resignation of Sonia Gandhi. It's like that only. IA is of the board. IA is giving report to the board. Board is referring the matter to the DC, and DC is also consisting of whole-time member of the board. And practically there is one whole-time member of the board who's constituting this DC. Should there not be minimum 3 members? So there, if there is a conflicting order, if at least the order can be passed with 2:1. Should there not be members from the outside? Should there not be members who is having some sort of judicial background or judicial mindset? Whether bureaucrats or officers of the board can pass judicial orders? Can they punish somebody? Where from they deriving this power, this authority? From the code. Should code give such authority, such sweeping power, such sweeping authority to the board, this whole-time member, to pass such a draconian order? In my view, these entire disciplinary provisions should be challenged. The constitutional validity of these disciplinary provisions should be challenged before the respective High Court, or maybe somebody will go to Supreme Court also. But so far, not even a single insolvency professional has come forward and challenged the constitutional validity of these disciplinary provisions. And now,
Sir, I have. Sir, I have.
Yes, Mukeshji.
I have challenged.
You have challenged the constitutional validity?
Yes.
What happened to that?
Because of the COVID, nothing was able. I'll discuss with you with the details, in fact.
I'm so happy, and Mukeshji, I'll be more than happy if you can share a copy of your petition with me.
So is it pending? Is it pending?
Yeah.
So, because I would like some others also to challenge these provisions, and whatever grounds you have taken in some other grounds can also be added to that.
But better, Mr. Badam, this should be done by the associations.
Sir, whether association does or individual does, but somebody must do it.
No, I suppose this is a good suggestion from association. If it is done, in fact, I suppose it may have better. And one more thing, Madanji, sorry, I am interrupting you in between, but I was just thinking one more thing. In every act there is should be a system, in fact, कि Companies Act में कि अगर आपने ये default किया तो ये penalty लगेगी, penal IPC में होगा कि भाई आपने ये किया तो आपको इतने दिन का जेल मिलेगी, आपको ये मिलेगा. I suppose there is no such provision in under this IBC. उनकी मर्जी है, सिक्का उछाला, देखा अच्छा इसको 1 साल के लिए कर दो, अच्छा सिक्का उछाला, अच्छा इसको पेनल्टी देके छोड़ दो, किसी को कहा अच्छा इसको वार्निंग देके छोड़ दो. So I just want to understand from you, it was a question in fact coming to my mind most of the time, कि भाई ये कहाँ से decide करते हैं कि किसी को 1 साल, 3 साल, 5 साल, 10 साल penalty, warning, and you will find many orders, in fact, in maybe recent past also, that where they have told that, after so much of a non-compliance, but it's a new act and only warning need to be given. Maybe in 2016-17 they might have passed very strict orders, and later on only warning maybe for the reason that it's a new act. So these were two points which I wanted to be clarified. One, that what penalty for what non-compliance. जैसे मैं बताऊं आपको, मुझे कहा कि भाई आपने ईमेल ठीक नहीं लिखी, आपने 25,000 रुपए फीस ले लिया, एक में वो ज्यादा है. So many things I suppose COC need to decide. So just my thoughts, sir.
Yeah, 1 minute. Can I interrupt, please, on the point of law?
Yes, please. Yes, please.
Yeah, 2 to 3 points I have got a submission to make. First of all, there are points of the legal fraternity that we have consulted advises us that the court will ask a question that अगर investigation या inspection हो जाएगी, so what harm will get done? And the court will are not ready to provide a relief because IBBI is not following the law. They are not having regard to the limitation provision. They are not having regard to the locus provisions also. So, what is the opinion of our association in that regard? Because incrementally, when you consult the legal people, they tell you that there is unlikely that any High Court or Supreme Court will give you relief, and in that case, IBBI will become more vindictive.
सर देखिए, मैं आपको एक बात बताना चाहूंगा. We are having a lot of talk as far as association role and other things are concerned. I must tell you that this is, in fact, me and Mamta, who has also joined right now, we thought of both that
Good afternoon.
this is good afternoon. Welcome, ji, welcome, please. We understand your limitation. देखिए, despite all this, you are joining us. Thank you very much. इसीलिए हम लोगों ने कहा कि मुकेश जी सर से भी बात हुई थी, मदान सर से भी बात हुई थी, सिंघी सर से बात हुई थी. हम एटलीस्ट एक शुरुआत तो करें, एक प्लेटफॉर्म तो हम आईपीएस जो इससे अफेक्ट हो रहे हैं उनके लिए करें, और लेट्स अंडरस्टैंड व्हाट रियल प्रॉब्लम इज. अब
सर यू आर म्यूटेड.
Manoj ji, you are on mute. Manoj ji, you are muted.
I'm sorry I spoke at length, but I was muted. What I mean to say is that I repeat what I said earlier कि हमारी एसोसिएशन ने मी एंड ममता जी इसी करके शुरुआत करी, so that let's have some sort of consensus. Let's understand what pain people are passing through. एक बारी हम इस पेन को समझ लें, और सर मदान सर हमारे साथ है, सिंघी सर हमारे साथ है, and other advocates are also with us. And if it is advised that it should be rooted through some challenging prison or something like that, so we shall definitely proceed for that also in the days to come. But everything goes step by step. अभी हम लोग हम जो सब लोगों की पेन है, एटलीस्ट हमने एक प्लेटफॉर्म तो प्रोवाइड करा कि जो भी सफरर हैं, या जो मैं तो ये कहूंगा कि एवरीबॉडी विल सफर इन द डेज टू कम. द वे थिंग्स आर मूविंग इन IBBI, जो बंदा काम करेगा उसके डीसी आएगा ही आएगा, और टाइम भी है कि वो अब आए, 6 महीने बाद आए, साल बाद आए, 1.5 साल बाद आए, 2 साल बाद आए. So before everybody got affected, we shall try to see to it that it doesn't happen. Sir, please carry on.
Thank you.
Madan sir, can I ask you something, please?
Yes, Sumit ji.
Sir, I was looking after this regulation 11, in which clause 2 clearly has stated about what could be included in the show cause notice, and further 5 says
Regulation 11
of the IBBI insolvency professional regulations.
Okay.
And clause 5 clearly states that the board shall constitute a DC committee, but it does not outline who will be the members, how many will be there. So up till now, as per your wide and rich experience, sir, is it like
Please read section 220.
Section 220. Okay, sir. Right, sir. I'll do that.
The constitution of DC provision is there, section 220.
Madam, you didn't answer my question actually. When you go and the court will ask you a question that what wrong will happen अगर inspection और ये process हो जाएगा.
Mr. Nimit, आपकी ना आवाज echo कर रही है, तो properly आप क्या कहना चाह रहे हैं? We are not able to understand. आपकी आवाज बहुत echo कर रही है. Or you can write in the, if you can write in the chat box, certainly we will take up your views.
Let me try to repeat. Now you are able to hear me?
And one suggestion has come, please take the question afterwards. You need to, Mr. Chairman, Mr. Manoj, you need to decide it.
Yeah, my humble submission to everybody is like that it happens many a time. We have seen in most of the webinars कि बहुत सारे हमारे मन के क्वेश्चन होते हैं जो स्पीकर ऑलरेडी उनके आंसर ड्यूरिंग डेलिब्रेशन दे देता है. तो let him complete all these things, and we can note down everything whatever we have in our mind, and with the passage of time यानी कि एक थोड़ा सा हम पॉज लेके उन चीजों को ले लेंगे अभी। सर प्लीज, मदान सर आप प्लीज कंटिन्यू करिए, और आई रिक्वेस्ट सिग्वी जी, इसमें अगर आप कुछ इनपुट देना चाहें मदान सर के साथ तो प्लीज यू आल्सो गिव योर इनपुट सो दैट यू नो वी हैव द मैक्सिमम बेनिफिट।
I will
चलता चलना जरा, हाँ
add in the disciplinary committee once sir finishes.
मैं
Then
चलना, तुझे लेट ना करिए ज्यादा। हाँ
Rupesh ji, please mute yourself.
बहुत आधे घंटे चला ले।
Rupesh ji, please, Rupesh ji, mute कर लो please.
मैं सबको करूंगा म्यूट तो सब म्यूट हो जाएंगे फिर।
नहीं, आप मत करो।
हाँ जी प्लीज कैरी ऑन सर, कैरी ऑन।
मनोज जी, ये टॉपिक इतना इम्पोर्टेंट है हम सबके लिए, इट इज क्लोज टू आवर हार्ट बिकॉज इट इज टचिंग आवर प्रोफेशनल लाइफ, आवर कैरियर, आवर रेपुटेशन। इसको पर इतने क्वेश्चन, इतना डिस्कशन हो सकता है कि आई डोंट थिंक इन द 2 घंटे, मुझे लगता है 1 दिन भी पूरा कम पड़ेगा इसको पर डिस्कशन करने के लिए। And I can understand the sentiments of the participants. Certainly everybody would like to say something, to speak something, to ask something, and in the 2 hours it will not be possible for you to please everybody. जैसे मैं कहता हूँ an RP cannot please everybody in a company, in a corporate debtor. Similarly here, Mr. Manoj, you will not be able to please all the participants who are present here today. So there will be some sort of limitations, and we need to adhere to these limitations.
Please, sir, carry on now. Carry on. We shall take the question after some time. I welcome Praveen ji.
Yeah, Manoj ji, since 2018, I've been fighting for the rights of insolvency professionals, almost at every forum. But slowly and gradually, now I have decided not to do that, to be very frank. And I tell you the reason. I started fighting for the rights of the insolvency professional because of section 27, which talks about replacement of a resolution professional. The provision says that if during the CIRP COC of the opinion that a resolution professional is required to be replaced, the COC may bring the agenda before the COC meeting, and by passing a requisite resolution with the requisite voting, that is 66%, may pass a resolution to replace the resolution professional. Now here my view is, the section says if during the course of the CIRP COC of the view that a resolution professional is required to be replaced. So these 2 things are there. Number 1, the COC is of the view, and number 2, that resolution professional is required to be replaced. There has to be some requirement, and COC should be of the view. And for this purpose, according to me, the COC must form an opinion that RP is required to replace, and this should be a reasoned opinion. It should be placed before the COC, and the RP should be asked to give response to this. But this process is not being followed. Principles of natural justice are not being followed, and RP, simply by passing a resolution for 66%, RP is being replaced. If COC is not happy with the RP is being replaced. It means the RP's independence is at stake. Every time he tries to please the COC, because if he is not able to please the COC will replace him by passing a resolution at 27. Sir, but that's fine. Okay, just a minute, Manoj. That's fine. 27, you pass a resolution. But while it's the question of replacement, now you are replacing the existing RP with another IP who is being proposed to be appointed as RP. Now, who is this new IP who is giving his consent without being in touch with the outgoing RP? On what basis is he giving the consent? Is he talking to the outgoing RP? That why the COC is going to replace you? Are you having any issues with the COC? Have your dues been paid? How COC has treated you during this entire CIRP? But वो नहीं होता है. Insolvency professional, तो sorry to say this, वो तो गिद्ध की तरह बैठे हुए कि एक opportunity मिले मुझे और मैं opportunity को grab कर लूँ जाके. One of the COC member approaches me that we need to replace the RP. Are you interested? He say, I'm more than interested. Here is my consent letter. कईयों में तो मैंने देखा CD का नाम भी नहीं लिखा होता और consent letter दे दिया जाता है. And slowly and gradually it is happening. And it is increasing. Now what is happening in these orders, the latest DC orders, where the discretion has been given to the COC. After that, order is effective, shall come into force after 30 days. And then a COC may decide, or copy of the order shall be given to COC. COC may decide whether to continue or to discontinue with these services. Abhi kal ek matter, and I was so shocked that without taking up the matter to COC, 30 days period has not expired. The heir of the company, it's a real estate case, authorized representative, who is also an insolvency professional, within 3 days he files an application for replacement. Within 3 days of passing of the DC order. अरे क्या सोच के बैठे हैं हम कि हमारे आरपी के अगेंस्ट कोई ऑर्डर आए और हम उसे भगाए वहां से लात मार के. And what this AR says? This AR says, I am COC. This written in the, and he files an application under section 27. Just believe it. He doesn't go to COC, doesn't get a resolution passed. He on his own, he files an application under section 27. Section 27 very clearly says copy of the resolution of the committee of creditors. Now this AR files an application under section 27 for replacement of the RP. And along with this application, he also files a consent from the another insolvency professional. अब आप सोचिए, एक IP RP जिसके अगेंस्ट ऑर्डर आया है, we should have sympathy with that person. We should go through the order, whether the order has been passed on merits or not. 30 days period is given. He's in the process of filing a writ petition. He may get a stay order. But this AR, who is also an IP, is filing an application along with the consent of another IP. So two IPs are after the life of another IP. हम बाहर किससे सपोर्ट मांगने जाए, किसके सामने रोएं, किसके सामने जाके बात करें? हमारे अपने घर के लोग ही हमारे अगेंस्ट हुए. P guys accuse IBBI, we accuse IPA, we accuse adjudicating authority. पहले अपने घर में झांक ले, हमारे लोगों में क्या है? You said very rightly 4,500 हमारे IPs है टोटल कुल मिला के. उनमें से मुश्किल से 2400-2500 के बाद AFA होगा. And out of the AFA, how many are having the assignments? Those 1,000-1,200, they are not united. This 1,000-1,200 professionals all over India are not united. And all others who are having AFAs and not having any assignments, they are ready to take up any assignment at any price under any eventuality. This is what our expectations from the professionals. We in our respective profession, whether CA, CS, LLB, or lawyer and all that, do we take up our assignments like this? I never take up any assignment as a legal counsel in between of the case unless I get a no objection from the erstwhile advocate. I never take up any such assignment. Forget about what is the code of conduct. Should we not have our own code of conduct? We are professionals having more than 2 to 3 decades of practical experience exposure. Are we waiting for this in legislation to come and then to decide to have our livelihood? We were doing very well in our respective professions otherwise also. Now, all of a sudden, what has happened? What's gone wrong? Anyway, these are not some of the not only emotional and sentimental issues, but some practical issues also.
Sir, इसमें मैं एक चीज और ऐड करना चाहूंगा. अब पर्सनल वेंडर्स के केसेस भी आ रहे हैं. इसके अंदर तो डेटर को ही पावर दे दी गई है आपको रिप्लेस करने की, सेक्शन 98 के अंदर. बेसिकली वो है कि जज को ही ये पावर दे दी गई है कि उसका जो एप्लीकेंट या डिफेंडर है उसको रिप्लेस कर ले. सर थोड़ा सा मैं इसके बारे में एलाइटन करना चाहूंगा. और रही बात दूसरी एनओसी लेने की, in our CA profession, I'm a CA, so we can never take any assignment without taking NOC. But can that be extended? Now we have to take urine for everything, for every certification, even for IBBI certification also. So can that, the thing be extended here also? Maybe we are not working for under the Act of CA Act, but we are working under IBBI Act. Sir, ये दो बातें थी मेरी.
Madhan sir, can I speak something on this subject? On the issue?
Yes, Ramanji, please.
My video is off, sir, because I'm traveling. my submission is that we all must have some mandatory requirements from the IPA to be a member, and all the members must adhere to the regulations, guidelines, or code of conduct of the IPA, so that the issue which you have just highlighted should not happen. This is my submission.
Thank you, Vishnu ji. Thank you. Sir, Madan sir, आगे चलिए, please. Thank you. We try to implement it.
I think somebody wrote the constitution of DC. I think section 220 is very clear. 221 subsection 2, section 220 subsection 1 says, the board shall constitute a disciplinary committee to consider the reports of the investigating authority submitted under section so and so, provided that the members of the disciplinary committee shall consist of whole-time members of the board only. I don't think there is any doubt on the constitution of DC. It's very clear that only whole-time members of the board shall constitute the DC. No, but recently what has happened?
Madan sir, actually it talks about the whole-time members.
Yes.
So can the committee of the single member also?
Interesting question. Then they will go to the General Clauses Act that plural includes the singular also.
Okay.
I agree with you. I agree with you that whole-time members.
This issue of one member, we have challenged it in High Court, sir.
Good.
Yes.
Thank you. I think Nipun jab kya hona chahiye means I think there should be multiple writ petitions across the country, and then all should be consolidated, and these should be transferred to Supreme Court.
Yes, sir. Yes, sir. Yes, sir.
Absolutely correct.
Yes. Absolutely.
Yes, yes.
So I think that all the members who are present here from the respective states, they should take this initiative. Geeta ji, you can do it Chennai, and other high courts also. You can do it in Madras High Court now, actually, but Chennai is not the High Court, Madras High Court. So
Why can we challenge the whole process?
Nimit ji, आपकी आवाज echo कर रही है. Please, we are not able to understand.
So I call you after that, after I get the availability from your personal home.
Sir, आप chat box में लिख दीजिए, please.
So can I ask a question?
Yes, Mr. Gautam. You are on mute.
Sorry. If notice is not issued to someone, even then can he challenge the provision before the High Court?
आपसे locus पूछा जाएगा. What's your locus? In what
So it
capacity?
is-
Are you filing a writ petition or say PIL?
So because being an insolvency
How you are an
professional,
aggrieved party?
so it is only to those insolvency professionals to whom notices have been issued, they could challenge it before the High Court.
I'm not just saying you can or you cannot. I'm not responded to that. The
Okay.
only thing is that you have to demonstrate, you have to establish your locus.
Okay. So
क्योंकि सारी
Sir, we'll
चीजें
give lot of points.
सारी चीजें यहाँ डिस्कस नहीं हो सकती है.
चलिए सर, आगे please carry on. Yeah. Gautam ji, it can be done. What you are thinking, it can be done. How it can be done, Madan sir will guide us. Sir, आगे चलिए please.
निपुण जी, before I come to the practical case study,
Yes.
अभी तक का जो process discuss किया है और the provisions discuss किए हैं, if you put your views on that, that will be better before. Then I'll come to the practical case studies, which I have handled and you have handled.
Correct, sir. So, sir, as you have already discussed the constitution of DC, I could find one contradiction amongst the section and the regulation, which we have also challenged in the High Court. Now, sir, if we read the inspection and investigation regulation, there also disciplinary committee they have defined. They have defined it in regulation 2C. Now, regulation 2C of IBBI inspection and investigation regulations.
Okay.
So, should I read it out, sir?
Yes, please. Why not?
Yes, please. Yes.
So, regulation 2C says disciplinary committee means a committee of whole-time member. In the bracket, they say S.
Yes.
Constituted by the board under section 220 subsection 1, provided that the whole-time member in the disciplinary committee shall not be associated with investigation or inspection. Now, my interpretation of this is the person who has formed an opinion when an inspection or investigation was carried out, that person cannot be the same person when this DC is hearing our matter. Now, interestingly, sir, when we see the website of IBBI, and historically, if we see what DC was, so previously they were appointing 2 members in the disciplinary committee. So it was consisting of 2 whole-time members. Then they shifted it to 1. And as on date, they are having 2 disciplinary committee, DC1 and DC2. DC1 is headed by a chairperson and DC2 is headed by 1 whole-time member. And when I historically again went into it, there has to be 2 whole-time members. So again, if we read the constitution of the IBBI, it says there has to be 3 whole-time members. And there are only 2 whole-time members. And the one has joined just in the, I think, last 10 or 15 days. So when the matter was being heard and order was passed in one of my cases where I appeared, I have noticed that it apparently clear that the same member who has passed the order was also connected with inspection and investigation. So that is one of the things I just wanted to point out for all the participants. There is a inbuilt bias which is happening today. Most of the matters, this I have noticed, the DC itself, and going by the dictionary meaning what Madan sir has already said, committee means 2 members at least. Committee cannot be of a single member. And assuming that there are 2 members in the whole time committee, in the whole this DC committee of whole time members, then the question of that having a binary opinion goes away. So 2:1 has to be there. So though we have not gone to the extent of challenging that it should have 3 members, but we have gone to the extent of challenging it and saying that it has to be at least 2 members. But this is probably, let's see what court decides. But this is one of the issue which I think is of utmost importance, and it's a mutual contradiction between the code as in the regulation.
Now, on this issue only, Nipunji,
yes, sir.
I put it in this way. Whatever you have said, that only, but I put it this way. First of all, I go to the definition of the word board. Section 2, subsection. Section 2, Nimit, please mute yourself. Mr. Nimit, please mute.
Madan sir, in the press, you have muted yourself.
Sorry. Board means the Insolvency and Bankruptcy Board of India under subsection 1 of section 188. So if we come to section 188, it says establishment and incorporation of the board. And then section 189 says the board shall consist of the following. What is that? Chairperson, 3 members from so and so, 1 member so and so, and 5 members from so and so. So the whole time member is here. The board shall consist of a whole time members.
It has to be minimum 3 as per D, clause D.
Right. Now I see. The board shall consist of 1, 2, 3, 4 says 3 whole time members. And when we say that investigating authority shall submit report to the board. And what is the definition of the board? Including whole time members. And then you say that DC will consist of whole time members who is not part of the earlier proceedings.
Correct.
But in earlier proceeding, this board has received a report from the IA. And board means whole time member also. So that's what I'm saying. Who is giving report to whom, and who is it deciding this report, and who is deciding this issue? The whole system is, as I said, full of flaws. I'll say to the extent of illegal. It's absolutely illegal.
In fact, sir, if we read the constitution of board, it makes a distinction between chairperson and whole-time member.
Exactly.
So in my view, chairperson cannot be part of DC.
And that is why these 2 orders of Ludhiana insolvency professionals, which have been challenged before Punjab and Haryana High Court, the first case was decided on conflict of interest basis, that in that particular case, Punjab National Bank was the complainant.
Correct.
And the chairperson who constitutes DC, chairperson IBBI who constitutes DC, was on the board of Punjab National Bank at some point of time. So there is a conflict of interest. On that basis, that case has been, the order has been suspended. And the other case, in the other matter, which has been suspended. I think Mr. Bhupesh Gupta was very much here. I don't know whether he's there still or not. That has been decided, order has been suspended on the basis that a chairperson, that it has been challenged there whether chairperson can be considered as whole-time member and whether he can constitute DC. So on this issue, that matter has been, the issue has been suspended. But let's see what the courts decide later on. But after that also, surprisingly, the chairperson-led DC is still functioning and passing orders. That order of Punjab and Haryana High Court has not acted as a deterrent. It should have. Actually, it should have, but that has not acted as a deterrent. But if some insolvency professional does any act like this, that some other case and order has been passed, and the insolvency professional who is not connected with that CD does not follow that order, it may be said, no, why have you violated the provisions of the law? I tell you the reason, yeah.
And they will cancel the registration.
Yes, Ashokji.
Sir, what you said, sir, this also finds some support in section 193, which says that member not to participate in the meetings in certain cases. So therefore, if that particular member of the board is actually interested, he cannot even participate. So what they say is a report is given by, let's say, inspecting authority or investigating authority before the board for consideration, wherein they proceed to issue a show cause notice also. So if that person is related, he can't be there in the meeting also.
Right.
So that is also one of the grounds, because I think that I read that order of Punjab Haryana High Court, wherein ASG had submitted that though he was interested, but all principle of natural justice have been followed. So if he was present itself, the principle of natural justice goes away.
Yes. You know, in Companies Act, there are two provisions, one with respect to interested director and another is with respect to a director who is a related party. And the law goes like this, that if in a board meeting, if a director is interested in a particular agenda item, he shall not be counted for the purposes of quorum. He cannot participate in the discussion. He cannot count his vote. He cannot cast his vote. And if the chairman of the meeting is also an interested director, he has to leave the position of the chair and some other person has to be appointed as chairman for that particular agenda item. And it goes further that if a director is a related party in a particular agenda item, then before having discussion on that agenda item, the related party director has to leave the boardroom. He cannot remain even present during the meeting at the boardroom, in the boardroom. So such laudable provisions are already existing in the sister legislation. Because certainly we are supposed to comply with Companies Act also. Why don't we borrow those provisions and comply with those and follow in our practice?
Another, sir, aspect of inspection and investigation regulation, which I think is misused or maybe not used properly. As you have said, sir, that whenever the order is passed, we have 30 days time. But now, sir, orders are passed which are having immediate effect. So that time period of 30 days is also now gone away. In fact,
I faced this music, Nipanji, yesterday.
Yes, sir. So same issue I am also facing, sir, for 30 days. And that immediately that AFA is not revived. You have to comply with the directions. You do not have a way to exit. And there is no procedure of doing payment or doing some directions compliance by under protest, which normally in other laws we have, that we may make the payment under protest, move for writ petition. Here our right to do business itself gets blocked away.
What has happened yesterday, the 30 days period from the date of the DC order is going to expire on 30th of July. And yesterday itself, the adjudicating authority has decided on the application of the same AR, which I was referring to, that after 30 days, the RP will not have any right to convene a meeting of the committee of creditors because his license is already suspended. Therefore, yesterday this RP has been directed, existing RP has been directed to convene a meeting of the COC within the next 7 days. That is before the expiry of 30 days. So where is the question that the order will come into effect after 30 days? And last year, I tell you, in another case, the interesting thing has happened. An insolvency professional, an order has been passed against an insolvency professional that you shall not take up any fresh assignment for a period of next 1 year. However, you are directed to continue with all your existing assignments. This order is hosted on the website of IBBI at 10:30 a.m. Very same evening, this IP receives an advance copy of application from IBBI's lawyer. This application is filed before adjudicating authority for replacement of this insolvency professional, who has been directed by IBBI to continue with the existing assignment. Same IBBI is filing an application for his removal on the very same day. और चंद घंटों में application नहीं बनती है. Within next 5 hours, he received this application. It means before this order is passed and hosted on the website of the IBBI, before that, his application for his replacement removal was ready. I mean, where are we going? What are we doing? If our own regulator behaves with us like this, where should we go? And unfortunately, Delhi High Court does not grant any relief in this disciplinary order. That is very unfortunate. So I think all those insolvency professionals whose office address is outside Delhi, they are lucky enough they can approach their respective high courts of the respective states. But because in Delhi, it's very difficult to get any interim order. Your term will be over, but hearing will not be complete. Notice will be issued, no doubt. But pleadings will not be completed by the time when the term is over. Mr. Viral Vora, you want to say something or you want to mute yourself? Manoj ji, mute kar dijiye, please. Yes, Manoj ji, before we come to the cases, if we are having some more members want to have discussion on these issues which we have discussed so far.
So we can go to the chat box and see there.
You just raise these issues one by one, or if somebody wants to speak or raising the hand, you may allow that member. Mr. Manoj Singh has
Sir, I think we should continue because the time is already 4:08 and we shall take all this things at the end of the meeting. Yes, please. Yes.
मदान सर, मैं ऐड करना चाहूंगा, मेरे मैटर में IBBI ने फर्स्ट एप्लीकेशन फाइल किया था फॉर रिमूवल before, just 3 days before the issuance of draft inspection report. They have filed the removal of the IRP. This is the first case in the IBBI history.
क्या मनोज जी क्या कह रहे हैं? मनोज सिंह जी
समझ में नहीं, इन्होंने कहा कि मेरे केस में मेरा पहला केस था।
मेरे केस में IBBI ने किसी भी आरपी को रिप्लेस करने के लिए जो एप्लीकेशन फर्स्ट टाइम फाइल किया था, वो मेरे अगेंस्ट फाइल किया था, और वो फाइल किया था ड्राफ्ट इंस्पेक्शन रिपोर्ट इश्यू करने के 3 दिन पहले। They have filed
just a minute, मनोज जी, रिप्लेसमेंट फाइल किया था, रिमूवल फाइल किया था?
रिप्लेसमेंट,
हाँ,
रिप्लेसमेंट के लिए।
Okay, in my case, in my client's case, it has been filed for removal under Rule 11. Because replacement is under 27 and replacement can be filed only by COC. But here in this case, it was removal under Rule 11 or read with, section 60, subsection 5, clause C.
Yeah, Rule 11 is 65.
So replacement is not, that's not replacement, replacement under 27 only.
Okay, no, they have filed the Rule 11 65.
Yes.
तो लेकिन उसमें मेरा ये पॉइंट था कि जब इंस्पेक्शन इनिशिएट किया, ड्राफ्ट इंस्पेक्शन रिपोर्ट 26 मार्च को इशू किया और 23 मार्च को रिप्लेसमेंट और रिमूवल एप्लीकेशन फाइल किया। सो इज इट द राइट वे टू एक्ट एज ए रेगुलेटर?
You want me to give comment?
Sure, sir. If you.
I think your question is having the answer.
Okay, sir.
Okay. Yes, any other member wants to say something? Otherwise, I'll come straight away to some of the case studies.
Madan sir, is my voice audible now?
Yeah, it is clear now.
Not clear. मनोज जी आप सुन पा रहे हैं? चलो मनोज जी आप सुन के बताना जरा please.
Hello.
Yes.
Is my voice
हाँ जी
audible now?
हाँ निमेश जी बताइए, प्लीज कैरी ऑन क्विकली प्लीज।
सर मेरा ये क्वेश्चन है कि हम बीसी जब इंस्पेक्शन नोटिस आता है, इफ इट इज नॉट ऑन प्रॉपर ग्राउंड, कांट वी चैलेंज एट दैट स्टेज ओनली?
Before whom?
Before the High Court.
Try to do it.
We have tried to do that in some cases, but we have got an opinion that nobody is going to stop an inspection on the ground कि भाई inspection हो जाएगी तो क्या problem है आपको? What is that you are trying to hide?
But why do you want to challenge the inspection? Inspection is not a punishment. It's a routine thing.
Yeah, the procedure is harassment, sir. आपके सारे काम बंद हो जाते हैं, आप इसी में ही लगे रहते हो, and you have to say, you have to supply the whole Ramayana for the work you have done.
I can't hear.
सर वो ये कह रहे हैं कि आपके सारे काम बंद हो जाते हैं, फिर आप उनके रिप्लाई में ही लग जाते हो।
That's
why we
okay.
want to...
That you know, before we take up the registration insolvency professional, we are aware about the provisions of insolvency and bankruptcy code and the regulations that there is inspection investigation provision, and as there is a code of conduct, and we are supposed to cooperate with the inspecting agency. We just simply can't take this plea that it's going to take much of time. We have to.
No, but there can be cases that that inspection order has been made without jurisdiction.
Yeah, that's my point only. For example, if it is a complaint is let's say time barred, then how can you do the inspection on the basis of a time barred complaint?
So wherever it is time barred, they will not tell you any reason why the inspection is being carried out.
So that's what I am saying. If they do, they try to take shelter in the 218.
It can be routine inspection also, but I don't think we should challenge the inspection also. Why they are conducting the inspection? Are we afraid of this inspection?
Sir, my question is, if you have to go through the whole process, then a lot of harassment is in the process rather than the outcome.
What is the harassment in the process, inspection process? They are asking for certain information, and you are giving the information. What is the harassment? I'm sorry, I can't take this view from you. If others are of the view, Mr. Kriplani says yes, it's possible.
No, I am saying that sometimes the inspection order are also without jurisdiction. They have been issued by the incompetent authorities.
That I agree. That is a separate issue. That's a separate issue. But simply because I should not be inspected, inspection of
that cannot be that cannot be.
Yeah.
Chaliye sir, we have scarcity at times. Please carry on with live cases and then.
Okay, now I come to one of the recent cases in which the order has been passed only, I think this week only. I come to some of the issues which have been raised in this particular order. First of all, let me tell you the background of this corporate debtor. This corporate debtor, with respect to which this insolvency professional was acting as resolution professional, it was having 3 different facilities, production facilities, in 3 different geographical locations of the country. Think of this. 16,000 employees, running units, continuous process industry. 1 मिनट के लिए भी फ्यूल की सप्लाई बंद नहीं हो सकती है। फ्यूल की सप्लाई बंद हुई तो फर्नेस बंद हो जाएगी, फर्नेस बंद हुई तो पूरी प्रोडक्शन रुक जाएगी। And you need continuous repair and maintenance of the refractories also, of the furnaces also, for which you need refractories also on continuous basis. And whenever those who are from the continuous process industry and having to face these refractory furnaces, the refractories for these furnaces are tailor-made. अब ये नहीं है कि आज आपने A से लिया, कल को B से खरीद लोगे, फिर C से खरीद लोगे. That's not possible. जो रिफ्रैक्टरी लगी हुई आपको उसी के मैन्युफैक्चरर से, देयर मे बी पॉसिबिलिटी में गेट इट फ्रॉम समवेयर, बट इनवेरिएबली 99% आपको उसी से ही खरीदनी पड़ेगी. In such a scenario, in this entire process, company ki turnover during the CRP is increased by 2.5 times. The company was into losses by the end of the financial year in which this CRP is over. Company is having a profitability of 4,000 crores of rupees. Against liquidation value of 12,000 crores of rupees, the resolution plan is there for 20,000 crores of rupees. Now, ऐसी कंपनी के आरपी को आप शाबाश दोगे, रोल मॉडल बनाओगे या उसके अगेंस्ट डिसिप्लिनरी एक्शन लोगे? Now, disciplinary action is on what basis? What are the grounds? What are the observations in the show cause notice as well as in the disciplinary order? The first is, one of the operational creditors files a claim as operational creditor, admitted as operational creditor. Then this operational creditor decides to change its category to other creditors. I don't know why. Then again reverts back to operational creditor. Now, RP admits him as operational creditor. But in the meantime, what happens? During the course of this pre-CIRP, some arbitration proceedings were pending between the company and the operational creditor. Now, if arbitration proceedings are pending, you never know what shall be the outcome of the arbitration proceedings. Now, the resolution applicant in the resolution plan considers this operational creditor as contingent creditor. Simply because the arbitration proceedings are pending, they may be in favor of the corporate debtor and this creditor does not remain even a creditor. So that is why this creditor is treated as contingent creditor. Now, during the course of CIRP, against this decision of the resolution applicant of treating himself as contingent creditor approaches NCLT. NCLT dismisses the application of the operational creditor. He approaches NCLAT. NCLAT dismisses the appeal. He prefers an appeal before Supreme Court. And then he files an application before Supreme Court for withdrawal of his appeal. And that application for withdrawal is still pending. Now it means he has done complete forum shopping. Every order is against this operational creditor, against the decision of the resolution applicant of considering this creditor as contingent creditor. Now IBBI says there is no provision in law of treating somebody as contingent creditor. Now, if the resolution applicant has considered this creditor as a contingent creditor, it means this resolution plan is not in compliance with section 30 subsection 2. And you should not have brought such a resolution plan before the COC for its approval. How come this particular creditor has been considered as contingent creditor? Think of this situation. All the judicial forums have decided against him, against this operational creditor. And the resolution applicant is having a justification. COC is having a justification of treating this creditor as a contingent creditor. Do we think that IBBI, then during the course of the disciplinary proceedings, a question is raised. Are we subject to NCLT, NCLAT or Supreme Court? Which simply means that we are above all these authorities. And ultimately, in the disciplinary order, this resolution professional has been held guilty that he has not complied with law. Now, simply think of a resolution plan worth rupees 20,000 crores. The CD has been kept as a going concern. All the employees have been paid all their regular dues, including salary, bonuses, everything. Company has come into profits. You are punishing a resolution professional. You are punishing a resolution professional for keeping a company, treating a CD as a going concern. Another allegation. There are certain suppliers, particular coal, oil, trade unions, truck trade unions. You know it very well, the truck unions, how to operate in states. अगर ट्रक यूनियन डिसाइड कर ले हैं कि यहाँ पे बाहर का एक भी ट्रक नहीं आएगा तो नहीं आएगा. If truck union decide only मेरा ट्रक चलेगा तो चलेगा. If truck union decides इस फैक्ट्री से कोई भी माल लोडिंग और अपलोडिंग नहीं हो सकती है तो नहीं होगी. These truck unions are so strong in each state, in each district. Now in this case what happens? For purchase of this coal, for purchase of this oil, for taking the services of the transporters, all these authorities, all these unions and the suppliers, they insist that unless our previous dues are paid, we will not supply the coal, we will not supply the oil, and we will not lift your material from the factory. The fourth scenario in this case, there is some supplier who just stores the gas and burns the gas so that this gas, particular gas, does not harm the environment. Now, this particular agency also blackmails the resolution professional. Unless our previous dues are paid, we will not continue our services. And if it decides not to pay to this particular agency, the gases will be emitted in the environment. And the people in the surrounding area, they may get killed also. So he decides to make payment to these agencies and these authorities. The show cause notice is issued. He replies, gives evidence, everything, but IBBI says, sorry, these are pre-CIRP expenses. They should have filed the claim. You cannot make payment to them. Now, a resolution professional in majority of the cases is having these issues. Number one, to keep the company as a going concern. And number two, to comply with the provisions of Section 14 moratorium. तो या तो moratorium follow कर ले या CD को going concern रख ले. Now in this particular case, if the RP decides to comply with Section 14, that there is a moratorium, I cannot make any payment to which are any expenses which are pre-CIRP expenses, very next the unit will get closed. And if unit gets closed, then also he is liable that he has not kept the unit as a going concern. So his choices between the two, whether to keep the company as a going concern or to comply with the provisions of Section 14. He decides that I will keep the company as a going concern. But the moment he does that, IBBI now comes into picture and IBBI says, sorry, you have not complied with the provisions. On the similar grounds, in a particular case, in another corporate debtor, similar grounds, same insolvency professional gets a relief from the erstwhile disciplinary committee just 3-4 months ago. Same insolvency professional, similar grounds. In that case, the DC agrees with the resolution professional. Yes, the CD was to be kept as a going concern and you have done a great job. So therefore, it's not a contravention. We accept your reviews. During this latest DC matter, we highlighted that particular the erstwhile matter. That there, erstwhile DC had decided like this, but this DC decides against the resolution professional. Another allegation in this very case, the resolution plan talks about that the resolution professional shall be monitoring agency and he shall be paid so and so amount per month. Now DC says you have contravened the provisions of, I think, code of conduct of 3A, right? I think 3A, clause 3A of the code of conduct of insolvency professional regulations.
23A.
maybe 23A. Yes, sir. 23A. 23A. And now this RP, he said this is part of the plan. And I tell you, this plan has been implemented successfully. Now the company stands handed over to the resolution applicant after successful implementation of the resolution plan. But IBBI says, sorry, you have taken an appointment, an assignment, and you are barred under regulation 20, this clause 23 of the Code of Conduct. He has given n number of justifications, but IBBI has not heard. The DC has not heard, agreed with any of the justification, and the RP has been held guilty of professional misconduct. Now, looking at these disciplinary orders, do you think the resolution professionals in the times to come, will they try to keep the CD as a going concern? They will simply try to do the compliances in letter only, tick in the box approach. Is CD, let the go CD to hell. Why should I be bothered? I have to save my skin first of all. कल को CD या यूनिट बंद होता है हो मुझे कोई फर्क नहीं पड़ता, लेकिन मुझे तो ये देखना है मैंने सेक्शन so and so clause so and so code of conduct so and so को comply किया है नहीं किया है. Because if we don't comply with it, tomorrow I'll be hanged. और मैं 30 साल की जो मेरी reputation है, that will be at stake because my order will be hosted on the website and to very next day it will be top of the town amongst the stakeholders. Maybe media will also now media has also started highlighting nowadays that IBBI has taken action against such and such insolvency professional. क्या इसलिए मैंने प्रोफेशन चुना है? Am I not providing services to the stakeholders? Am I not putting my contribution for the sake of the economy and the corporate sector? Am I not contributing toward the state assets of the corporate debtors? And if I do that, I'm hanged. Action is taken against me. Why so? I mean, these are the serious issues. मनोज ये तो सिर्फ एक केस मैंने किया. I have n number of cases where I have appeared, but I don't think time is permitting me. I would like Nipunji to take it forward, and later on we can take some of the questions from the participants.
Yes, Nipunji, welcome.
I'm sorry that मेरे कोई भी word किसी को भी harsh लगे, including the regulator, but मैंने मनोज जी से permission ले ली थी. I want to open my heart. I want to speak from the core of my heart. I'm not here to please anybody.
Sir, I can understand the pain which you are having, seeing the pains of VIPs. We can see your face and we can see how much pain it is giving to you. Sir, यही मैंने देखिए अब सर की मैं एक मिनट निपुण जी लूंगा. इन सारी बातों के अंदर मैं सिर्फ एक बात हम सब अपने प्रोफेशनल साथ करेंगे करना चाहूंगा मैं कि इसका what is the way out for that? Way out for that is, we have to take some steps. Number one, file petitions in respective high courts. Let that be clubbed and to the Supreme Court, and Honorable Supreme Court definitely take a pragmatic view as conveyed by Madan sir. Number one. Number two, अगर एक ट्रक यूनियन वाले बंदे हैं, अनपढ़ बंदे जो भी हैं, मैं तो ट्रक यूनियन तो फिर भी बहुत बड़ी बात होगी. मैं तो अपने द्वारका में मैं रहता हूँ, उसके आसपास एक टेम्पो यूनियन है, वो नहीं अलाउ करती है टेम्पो का एक पर्टिकुलर रेट के अलावा करने के लिए. वी नीड टू गेट यूनाइटेड. We need to get united. Let's take lesson from this thing. Let's presume a situation. एक ट्रक वाला सारे ट्रक्स नहीं देता. अगर हम सब आईपीएस मिलकर करते, हम नहीं काम करते. Who has an authority? हमारे यहाँ पे आईबीसी के अंदर 4 पिलर हैं. 4 पिलर में से आईपीबी एक पिलर है. एक आईपी ऐसा पिलर है जिससे बाकी तीनों पिलर स्टार्ट होते हैं. बट व्हाट इज हैपनिंग इज दैट सर ने जो बात कहा, एक छोटा हाथी और उसके आसपास बड़े बड़े हाथी उसको बचाने की बजाय मार रहे हैं. This is all, I have to say. Nipunji, please carry on. Sorry, sir, you have a lot of pain on your face, but I understand the sympathy you have with us, and this is all. Nipunji, please share your experience.
Sir, I think Madan sir ने बहुत अच्छे से जो पेन है वो एक्सप्लेन किया है, and that is really happening. And मैंने इसको थोड़ा सा statistically analyze करने की कोशिश किया. I'll just share one slide with you. Sir, is my presentation visible, sir?
Yes, sir, absolutely visible.
Okay. So basically, this is how I have seen the change in the mindset of the regulator. So, sir, 2021 में there were around 20 cases, and we can see that 8 were suspension, only 1 was there which was permanently not given the license. But here in 2022 हम लोग अभी midway आए हैं, we are in the middle of the year, and till date they have reached 31. Yes, Madan sir, please.
Nipunji, whether in 21 was it suspension or you will not take up any assignment?
No, sir, I have not compared the language, but yes.
That's very important because the suspension is causing more harm to the earlier suspension. What was not there?
Correct, sir. Correct. In fact, sir, मैंने इसको सिर्फ इसलिए बनाया है to give a view कि how they are changing the same lapses which were maybe otherwise only for a warning, at the best issue of error of judgment. Now they are saying it is a misconduct. In fact, the language itself in the order, as sir rightly pointed out, has changed to blatant violation of the provisions. Blatant violation of the provisions is a very serious issue. अगर किसी का blatant violation है, तो there has to be some finding by adjudicating authority, by NCLAT. I have seen cases where NCLT or NCLAT is not finding any fault with the RP. There NCLAT is taking a view that there is no wrongful conduct. There could be a issue of judgment. There could be an interpretation issue. But IBBI is going ahead and thinking that particular action to be a misconduct. Interestingly, Madan sir, I have also seen in the last year orders, there was some penalty imposed by IPA on a particular set of insolvency professional. On the basis that a penalty has been imposed, IBBI said that we are not going to take any action. I don't understand. This is a legal issue. Madan sir, I would like your views also on this, that as per IBC, they are running 2 parallel disciplinary proceedings, one with the IPA and one with the IBBI. At least I should know who is my regulator. And if it is better, one regulator is understanding my issue, I should be given an opportunity to make him understand my issue there. I am sharing one of the matters in which I appeared, and the order is something else, absolutely contrary to what is the finding of the NCLAT. Now, the case was, there was an admission of a financial creditor in the COC. There was only one member in the COC. We admitted him as a financial creditor because he was shown that loan is taken and he is in, as per the balance sheet, the loan is being appearing. So there is no problem. Apparently, any chartered accountant, if he sees the balance sheet, will take a view that he is a financial creditor. Petitioner and the suspended management, they both entered into a compromise settlement and they said that you move it to LA. Now, as an RP, he told that there is already one COC member. You have to take the approval of that COC member. And obviously, that COC member was not consenting because his amount was used somewhere in crores. So that matter went before NCLT. And the issue came that there were some agreements which were not put on record. And because of that, this is not a financial creditor. And therefore, you disregard this person as a financial creditor. So disregarded, 12A done, matter closed. Matter did not survive. But because NCLT said that these particular documents were not considered by RP, therefore we think that this person is not an FC and RP should have been more cautious. That is what the NCLT said. No adverse remark. Though, because it said like this, we don't know, tomorrow IBBI might come in. So it was taken into appeal. And in the NCLT appeal order also, court was of the view there is no adverse finding. So NCLT in the order says that there is no adverse finding casting any stigma on the IP. Therefore, we don't find anything negative which we should delete. And therefore, the advocate consented for withdrawal of the application. This is specifically written. He is withdrawing appeal with the observation that there is no negative remark. Now, IBBI misinterprets this particular order and says, because your advocate withdrew the appeal, that means there are some negative observation, and therefore we would punish you with 50% of your professional fee, and also you need to undergo the training. So now this is how the interpretation of judicial orders is happening, whereas, as Madan sir rightly said, they are a quasi-judicial authority. They are not above NCLAT or NCLT or Supreme Court. Another important aspect which they have come out with the Insolvency Law Committee report recently, they are saying that orders of the IBBI should be made appealable before NCLAT. And therefore, there should be an appellate mechanism inside the the code itself. That is what the committee report is saying. Now, my view is that we should be given one chance at IPA. Our IPA may understand the thing, and the constitution is also perfect, sir. If we read the IPA's order, there are 4 members. At least some professional and judicial mind is applicable. But that is not so when it is a single member. He goes by his own instinct and takes out that this is wrong. So that is one suggestion, Manojji, which we can make from our association, that the disciplinary action should be given to IPA, and probably if there is something, then it can go to IBBI. There cannot be under the code two cases under me. Both the cases are having disciplinary action on the same issue. In fact, what I read in 2021, the issue of AFA was there. They were penalizing everybody and saying you have wrongly accepted the assignment because there is no AFA, or maybe AFA is not renewed, maybe AFA is not applied on time, something like this were happening. Both the cases parallelly against the same IPs are running in IBBI as well as under IP. So that is one thing which I have seen from what is happening in IBBI. Secondly, sir, this is a table which I have made based on the orders of 21 and 22, wherein we can see that how in 2022, aggressively they are moving for suspending the licenses and not taking up assignments for 1 year, 2 year, 3 year, and sometimes they are also saying permanently you will not do this. I am unable to understand why there is a switchover on the same set of violation, which according to them required only a warning or maybe some interpretational issue. They are now saying, no, you can't do it. So therefore, I also suggest all the participants, whoever are aggrieved, please move before the High Court appropriately, because this system has to be fine-tuned and it cannot be left to judgment of a single person sitting in IBBI. It cannot be left with the decision of that person. There has to be a judicial mind. In fact, when I was making this writ, we were brainstorming for almost 7 days what all we can include. And sir, we came across a very good judgment of Bombay High Court, which ultimately was confirmed by Supreme Court, saying that suppose there is an authority, which is a quasi-judicial authority, it could be a tribunal, it could be a committee. If there is no appeal and directly there is only a writ provision is there, then all the provisions which should be applicable to quasi-judicial authority like tribunal would apply to that authority. So as sir said, final report of inspection is never given. And sir, one more gross case which I am handling, wherein inspection report is there, reply is given to the draft inspection report. After that, we don't receive any final report. Show cause notice is issued. Show cause notices take cognizance of some of the facts which were never there in the inspection. And the gap between reply to the draft inspection report and show cause is as large as 15 months. Whereas if we read the regulations, it says it should be, endeavor should be made from 6 months of the assignment. Now, if we have done an assignment, matter is closed, all the courts are reached the conclusion, maybe CIRP is closed, maybe withdrawal has happened. Now, after maybe 1 or 2 years, if IBBI is initiating disciplinary action, I do not have a recourse to rectify, because many of the cases, the orders I have interpreted, they say that a remedial action should have been taken. You should have approached by filing this application. You should have done this thing in so much time. My view is, if suppose IBBI was so concerned, we are intimating them each and every thing by filing, whether it is forensic report, whether it is any application, every sort of things they are interpreting. Everything is being monitored, but we are not given any chance during the assignment, and there is a post-mortem done after the matter is over. So that is something very egregious, which I don't think that is acceptable to any professional whatsoever. Another issue which I think is going to come is, if we do not challenge the order of the DC. Today, the view taken by recently in one of the matters of CA Institute, again, Delhi High Court confirmed that order. It was with regard to some misconduct which was happening otherwise by the member of the institute. They said that because there is a misconduct in so and so law, therefore now we are also issuing you a misconduct proceedings, disciplinary proceedings under the parent law. So if we are not going to stop this particular proceeding, ultimately tomorrow it might happen that the cognizance is taken by our parent institute, and again those proceedings would start. So this is again my view. Though sir has already taken this procedure and the lapses, so I am not again getting into these. Some of the orders, I think I just wanted to share it with you all, but this PPT, I think Manoj ji would be sharing with the participants. So one of the case already taken by Madan sir is that there was an inherent conflict of the chairperson and the complainant, and therefore straight away the High Court, Punjab Haryana High Court have stayed the order of the DC. Similarly, one more order of Delhi High Court, wherein what has happened is stay is granted on the basis of payment of the fee which is in the form of penalty to the IBBI. So such type of writs can be filed. Somebody asked that whether we will get a stay or not. My view is we will always get a stay, because if there is a penalty imposed by the IBBI, we should always make a prayer in our writ petition that without prejudice to what will be the final outcome of the writ petition, I am ready to deposit this money with the court. Now, if the court says you deposit with the registry, it's okay. If the court says you deposit it with the IBBI, it is okay. We are depositing money without prejudice. Similarly, in tax matters also we do it without prejudice, and under protest we make the payment, and then the matter gets stayed. So same argument we can also take here and get a stay. At least we will have to bring out the facts on record so that no wrongdoing can be alleged. See, as a matter of profession, we are aware there could be an interpretational issue, there could be an error of judgment, but that error cannot be misinterpreted into gross misconduct. In fact, I have seen Supreme Court saying that even if assuming there is some violation on the side of a professional, it could be tantamount to misconduct, but it cannot be a gross misconduct. There should not be a mala fide attached to that misconduct. So again, just Madan sir said, and this is my view, if we read the section 220, whereby IBBI is having the power to impose penalty, it says there can be only two quantification. One is loss suffered by any of the aggrieved person. So if some aggrieved person is not coming and his loss is not quantified, in my view, penalty of that amount cannot be imposed. Secondly, if it is proved I have made money during the process and there is some misconduct on my action, that has to be quantified. It cannot be like this, whatever fee you have taken, you refund. Whatever
that is regulation 12.
50%. Pardon?
That is regulation 12. Regulation 12 of the inspection.
Regulation? No, I am talking about the penalty imposed.
Yeah, actually, I wanted to raise the issue, but because of the time constraint, I didn't raise this issue. This penalty, according to me, can never be levied.
Correct.
Unless it is clearly established that there is some wrongful gain or wrongful loss.
Absolutely, sir.
Yes.
So because these proceedings are
incidentally, Nipunji, incidentally, in this Mohanlal Jain case, I am the one who represented Mr. Mohanlal Jain before IBBI. And just because of nothing, this poor fellow has been penalized. Actually, here again, there is a conflict between section 14 and section 25, whether to keep the company as a going concern or follow the moratorium. Actually, he saved net 9 crores of rupees for the corporate debtor. That was the actual conduct, and he has been penalized for violating the provisions of section 14, that moratorium, he has not adhered to moratorium. And ultimately, this case was withdrawn at the level of Supreme Court. CRP was quashed. There was no loss to anybody. But this poor chap has been penalized by IBBI. And you know, Mr. Jain, with full respect to him, former DGM of one of the public sector banks, having 40 years of impeccable record in his entire service. And then we are subject to these orders.
So, sir, I think we can now take the queries, because I will circulate this presentation. It has the summary of all the case laws with respect to 2021 and 22. I have bifurcated what are the violation, what is the penalty, and for what long they have suspended. So that I will circulate, Manoj sir. I think we can take the queries of the participants.
Mamta ji, you are, I think, online. Please, can you have some your views also and take care of all these queries? Mamta ji, aap please, if you're listening to me.
I don't think she is there.
Sir, I don't see any participants.
Okay. Praveen Jain ji, aap participants mein ho abhi ke you are not, because you are also co-host along with me.
Mr. Vinod and Mr. Sumit want to say something. They have raised their hands.
Yeah, you can unmute yourself and please have your queries.
Yeah, this is Vinod from Coimbatore. We are having a national platform through which, if we are getting a writ petition from Nipunji or Madan sir, we will be able to file in many high court. I am assure you that I will be able to file Chennai, Bangalore, and Kerala High Court. Okay, if prefer, we can go for other state also, especially Eastern. I think the other part of people may be having reservation, but this is my assurance. And Manoj was talking about the total integration of the IPs on one platform. There are many associations. We should look for a federation of all these associations so that many things can be taken up going forward. That's all.
Thank you.
Thank you very much. Thank you.
Yeah, Mr. Sumit.
Yeah, hi Nipunji. Thank you for the wonderful insights. Sir, I just want to know, you were saying that there is an idea being mooted that the appeals might be filed before the NCLAT. So what is your take that how much effective would be the procedure, because it is again a little narrow body being the appellate of the adjudicating authority if the appeals in any case are filed before the Honorable NCLAT against the orders of the DC vis-a-vis the writ mechanism of the high courts.
Sir, I think at least we will have some recourse, something to say before a forum which actually understand IBC. Because I tell you frankly, when we go to High Court, a High Court judge would never understand IBC because he has not seen in his life. Nobody in the last 5 years would have become High Court judge understanding the IBC. And the biggest challenge which comes before the court is to convince them what is IBC all about, what is COC, what is this procedure of suspended management. Sometimes it becomes very difficult nut to crack, and Madan sir would agree with me. In fact, even other judges, except NCLT judges, even other judges, they don't understand this concept that how somebody can take over the control and the management, how management would go away, how COC, which is a third party. So IP is a body without a brain, because they say that commercial wisdom is already with the COC. So we are working without brain. So this concept does not find good in the judges who have not actually gone through this new law. So again, it's a challenge, but I think before NCLT, we will get some relief. At least we will have a procedure before NCLT, then Supreme Court. Here, what will happen is in constitutional matters, what I have understood from my little experience over a decade is that when we go to a constitutional court, it was easy to get a notice issued or maybe get a stay. But then to actually get that matter finally adjudicated, it's a difficult task. And the issue involved would be against a regulator. And as we know, our regulator is too aggressive. So tomorrow they would also litigate it before the Supreme Court. So we don't know what would happen. So at least if NCLT is there, we will get some respite.
Right. So one last thing, you were mentioning an order in which you had also personally appeared, which I'm aware of, and in which the respected member, he was imposed a penalty. As also I see 11.8, regulation 11.8, which lists down what all actions can be taken by the DC. But interestingly, in this particular case, he was to undergo a pre-registration educational course. So is it in sync with 11.8? What is your view? Because it is no reprimand, no warning, and neither of the actions enlisted under 220.
I think that is overstepping the jurisdiction. IBBI has only that box. In fact, if you see the amendment, I think just 2 days or 3 days back, the amendment has got effective, wherein they say that in show cause notice, let's say there were A, B, C, D, 4 things. Now they've added 2 more things, saying that how the IP should respond to a show cause notice and what will happen if he does not respond to the show cause notice. Now these 2 things were missing. So in my view, if properly argued before a forum like High Court or Supreme Court, this show cause notice itself can be declared bad. I think Madan sir would agree with me. that these two parameters which were not there itself in the show cause, and now it is there in the amendment. It gives a constitution or an acceptance by the IBBI themselves that they were wrong in law. In fact, one more thing I just wanted to add, that the law says DC and whole time members should be separate. Those who are conducting inspection, those are doing the show cause. Now, my point is, suppose they are separate or they are single, how will I come to know as an aggrieved person? So that has to be disclosed in the show cause notice itself. So in my view, show cause notice itself is bad in law if it does not disclose who is the whole time member heading it.
Like in the notice of the shareholders meeting, and as per Companies Act, you have to disclose that who is interested in the particular resolution. You have to mention the names.
Yeah, Geeta ji, please carry on. You raise the hands, please.
I'm going to slightly deviate from the discussion topic. See, when the CDs, they do so many things and then they go scot-free. And in 180 days, IP is expected to do so many things, 120 regulatory compliances, and then the going concern part, and then so many, you'll have to convince a lot of people in the sense that, the COC, then the CD, the going concern, and then all the compliances, everything, and then why should he get punished so much? That's the saddest part, that where we are all in at this junction.
चलिए, उसके लिए हमारे साथ मदान जी और सिंघवी जी खड़े हैं, तो इस सैडस्ट पार्ट को हम धीरे धीरे करके खत्म करेंगे. विष्णोई जी, योर क्वेश्चन प्लीज. आई एम अनम्यूटिंग यू. या विष्णोई जी, प्लीज कैरी ऑन. अनम्यूट योरसेल्फ.
Yes, sir. Sir, thank you so much for giving me opportunity to put up my views. Sir, पहला तो जैसे हम लोग CRP में कोई काम करते हैं तो I am the officer of the court. तो हम जो ऑफिसर ऑफ द कोर्ट है वो कहाँ है? पहली बात, CRP में तो है, लेकिन IBBI जहाँ पे कोई मेंबर नहीं है, जैसे कि सबने भी कोई जुडिशियल मेंबर नहीं है, हम क्या वहां पे ऑफिसर ऑफ कोर्ट खत्म हो जाते हैं सेम प्रोसेस के लिए? I mean to say कि I think I have convey my point. First thing. Second, sir, आज हमें 5 साल हो गए, करीब 4 साल हो गए. आईपा भी हमारा बना हुआ, हम आईपीएस की कुछ एक्सपेक्टेशंस है कि हम सब यूनाइट होके काम करें. तो इसके डायरेक्शन में जो भी आपको लेना है, जो भी डिसीजन लेना है, जो भी काम करने हैं, हम सब उसके साथ है. तो देखिए, इंडिविजुअली आईपी सर लड़ नहीं पाएगा. रीजन क्या है कि वो कहीं ना कहीं लटका दिया जाएगा आईबीबीआई से. सबको फियर है. अगर एसोसिएशन आगे आता है कुछ करने के लिए, एसोसिएशन में किसी पर्सन का नाम नहीं आएगा, तो वहां पे हमारा इंटरेस्ट काफी प्रोटेक्ट हो सकता है. ये 2 सबमिशन है हमारे साथ.
थैंक यू वेरी मच. वी हैव ऑलरेडी टॉक्ड एंड देखिए, एसोसिएशन ने पहली बार ये मदान सर ने कहा, जिन्होंने आईपीसी के ऊपर मेरे हिसाब से, इनफैक्ट जब मैंने आईबीसी में बार-बार हर वेबिनार में कहता हूं कि मैंने आईबीसी का एग्जाम इन्हीं को सुन के दिया था वीवीएसएस के अंदर. तो कहने का मतलब ये कि 5 साल से पुराने हैं ये. तो इन्होंने ऑलरेडी हमारे को ट्रक यूनियन वाला एग्जांपल दिया. वी आर गोइंग टू इम्प्लीमेंट इट वेरी सून. उसी के अंदर ये था, lot of people are having a courtesy कि हम as office bearer IBBI में हमारा नाम चला जाएगा. मैं कहता no problem. We are doing it for the good cause of the community. We are doing it for the good cause of the IBC. Let's start a beginning. हमने एक beginning तो करी सब लोगों को इकट्ठा लाने की, और देखिए कितना अच्छा लगा है. और सर, एक और मैं मैदान सर मैं आपको बात कहूं, we have a very good participant which are touching around 100. और तो यानी कि thank you very much. We are going to have it. तो सर अब
I just want to say
yes, please carry on.
Yeah, I think even in the previous forums, I think and Madan sir very well knows, I have voiced my opinion. IBC is the business law. People mistake it to a compliance law now. Business come or compliance ज़्यादा. See, one of the ways is if you ask the regulator himself, बस आपका purpose क्या है life में? Compliance करवाना है, मरे हुए. I think they seriously take that legal aspect कि we have to respect the cop जो मर गया. We respect it, right? Legal में we have to respect it. That is how they're treating this. मरे हुए कंपनी को compliance का focus कर रहे हैं, जान ratherly quick decision से जिंदा कर सकते. I think they are missing the preamble itself, which takes that timely value maximization, and that's the core focus. So why can't this IBBI, are we not allowed to say that they should give a platform for everyone physically sitting across, and they hear out from the audience of IPs, one who have industry vast experience, and secondly, the experience of running for the last 4 or 5 years. Instead of they sitting and doing it. See, what they do is they keep sending the discussion paper. डिस्कशन पेपर तो हम तो सब लोग अलग अलग से देते ही रहते हैं, बट हाउ मेनी टाइम्स वी गेट व्हाट वी वांट? सीओसी का डिस्कशन पेपर हुआ था रेगुलेशंस का, महीने हो गया, कुछ तो निकला नहीं है उसमें। उनको जो चाहिए वो आ जाता है, उनको जो डिसिप्लिनरी कमिटी आ जाता है। It's not this the first forum that we are discussing the disciplinary part of it. I think somewhere we should actually ask them to face sit, understand, and then go ahead and put on something. Instead of we going for writ petitions. I understand writ petitions, I think, and that's a fantastic suggestion. But ये तो legal battle ही हो गई ना. Regulator को सीधा पूछो. After they don't hear regulators, that is when we actually go for this. And whom will they hear when an association?
The regulator is not open about that. Huh?
No, the question is in writing. Let them say they're not open about it. The point is today when I go to the court and all this, the first for me the first reaction is go to the regulator. Regulator को बोले यार आप लोग इतने साल लगा रहे हो, all IPs coming together, association, these are representative bodies, want to sit across collectively, not individual associations going and talking about it. Let them sit face to face, all the people who are sitting there, and let them explain preamble क्या है और वो क्या कर रहे हैं. And in that जो minute होता है, वो minute लेकर सीधा writ petition डाल देंगे कि this is how the regulator is behaving it, deviating from the core object करके. And as Madan sir rightly said, half the people are not interested to pursue anymore this particular aspect of IBC.
क्या किया ये? क्या किया ये?
नरेश जी कुछ नहीं किया, म्यूट करो।
मैंने कर दिया म्यूट उनको।
Energy, I was keenly listening you. The thing is that whatever the representation letter issued by even IPA, that even not addressed by the IBBI. That's the interesting thing.
And undoubtedly, I agree, Sir Mr. Vinod. The principle here is, I think when we are going, when I think Mr. Madan has rightly said, locus standi kada, those are things we get into those aspects of it. I think this is like last मौका जो बोलते हैं ना हम लोग IBBI को. Enough of this disciplinary committees orders. Enough of this. आप पहले बोलो regulatory is focusing on the core object or not. अगर regulator बोलेगा object change कर रहा हो, fantastic, we are okay with that. Anyhow, they are a delegated legislation body, right? Their legislature has defined something else.
So the best way is writ petition.
Vinod ji, I think Mr. Kripalani and Mr. Gautam Singhal, they have raised their hands.
Actually, I have the reason. Most of the orders I have seen under section 220, they don't rely, they don't base upon the regulation 12, sub-regulation 2, and especially further sub-regulation B. Which says, I will read it about, 12.2 regulation of the inspection. For the purpose of class E, which class E is the 12 sub-regulation 1E, the actions or direction that the board proposes to take or issue if the allegations are established. And for the purpose of this, I'm now reading 12.2, for the purpose of class E, which I have read already, of sub-regulation 1, the board shall take into account, but not limited to the following factors. Now, on these following factors only, they can take the action under section 220. Now, so this sub-regulation B, the consequences and impact of the allegation contravention, including unfair advantage gained by the noticee as a result of the alleged contravention, loss caused or likely to be caused to the clients or any other person as a result of the alleged contravention. And the third, the most important, the conduct of the noticee after the occurrence of the alleged contravention and prior to the alleged contravention. Now, they don't see the conduct of the noticee before the alleged contravention or even after the alleged contravention. They don't see, but they pronounce the order. So this under section 220, they should look into the regulation 12 and sub-regulation 2. That is my understanding.
Thank you. Yeah, Mr. Gautam Singhal.
Yes. Sir, by seeing such harsh orders, somewhat I am getting the feeling that IBBI is trying to scare away IPs who are natural person to give boost to the concept of juristic IPs which the IBBI is trying to push. So that an individual is not able to stand and he will always have less infrastructure, will get discouraged. And big IPs may come in. That's just an observation I wanted to make.
That could be that. That could be the reason, because the 4,000 IPs are there and not most of the IPs have the work. So they first, raise the numbers Now they may be looking, that now the work will not be there, so they want to definitely decrease. That could be the idea.
Because the discussion paper, which allows juristic IPs to take up the assignments in their names, IPs, so that will may get a boost, or that will be encouraged, because individual IPs will be discouraged. Every day or day after, every second day, there is a very harsh orders coming out.
गौतम जी, उसके अंदर बेसिकली आईपीएस को लाने का एक ऑब्जेक्टिव उनका ये भी था, ताकि बहुत सारी सर्विसेज आईपी से लेते हैं, तो उनके अगेंस्ट शो कॉज नोटिस इशू नहीं कर पाते. Now with this thing they be able to issue show cause notice.
सर लेकिन आईपी में भी नहीं कर पाएंगे सर. आईपी में भी वही रहेगा सर. जब आईपी क्लर्क तो नहीं बन जाएगा ना, वो तो आईपी तो वैसे ही रहेगा. वो तो सर जब वो पर्पस सॉल्व नहीं होता जो पर्पस उन्होंने कह रहे हैं डिस्कशन पेपर में. ओके, जो आईपी को जब वो आईपी का काम करेगा along with the name of the partner or director, so in that case I think they be able to serve the notice to show cause notice to the IP also. वो तो ठीक है, वो तो 2-3 आईपी जो होंगे जो मिलके करेंगे और उनको तीनों को ही सर्व किया जाएगा. लेकिन उसमें जो वो आउटसोर्स कर रहे हैं दूसरे मतलब प्रोफेशनल्स को, वो तो फिर फॉलो अप नहीं होता ना, पूरा सॉल्व नहीं होता प्रॉब्लम. चलिए, इट्स मैटर ऑफ डिस्कशन. Anyone else would like to add to this healthy discussion and with any suggestions or something like that?
But I'm so happy.
सर एक पॉइंट रह गया था मेरा.
शरण जी प्लीज कैरी ऑन.
सर इसमें ये था कि जैसे सीआरपी में जो भी प्रोसेस होता है एक्सेप्ट क्रिमिनल प्रोसेस, सारे के सारे केसेस एनसीएलटी में जाते हैं. तो ये सजेशन था, अगर कोई आईपी गलती करता है तो उसका भी केसेस एनसीएलटी में चला जाए, जो भी एग्रीड पर्सन है. इवन IBBI शुड फाइल एप्लीकेशन बिफोर दी एनसीएलटी, क्योंकि हमने बहुत सारे केसेस में देखा है एनसीएलटी खुद कहता है आप डिसिप्लिनरी की चिंता मत करो, आप एक्ट को फॉलो करो, जो होगा हम देख लेंगे. वो देखेगा कौन? एक केस में तो मदान जी भी थे जिसमें प्रॉब्लम थी. मदान जी आपको शायद याद होगा. बेंच ने कहा था कि आप अपना काम करिए, IBBI की चिंता मत करिए. तो IBBI से बचाएगा कौन? एनसीएलटी बचाएगा. जब सारे प्रोसेस का माई बाप एनसीएलटी है तो फिर ये डीसी और ये कहां से आ गया? तो ये एक सजेशन दिया जा सकता है डीसी को.
IBBI कभी भी अपनी पावर्स को डिल्यूट नहीं करेगा. दैट लेट्स एक्सेप्ट दैट थिंग. जैसा मेरे भी प्रेम्बल में मैंने सबसे पहले ये कहा ही था कि एनसीएलटी और एनसीएलटी इज द बेस्ट प्लेटफॉर्म टू अंडरस्टैंड व्हाट IBC इज देयर. सिगजी सर ने भी, निपुण जी ने भी आगे जाके कहा कि इट टेक्स वेरी टफ टू देम टू it takes a lot to impress high court कि IBC असल में क्या है. बट चलिए, जैसे लॉ नया इवॉल्व हो रहा है, वैसे ही हर चीजें नई इवॉल्व हो रही हैं. डेफिनेटली विद द पैसेज ऑफ टाइम, जैसे हमारे IBC के अंदर बहुत सारी लैंडमार्क जजमेंट्स आई थी ऑनरेबल सुप्रीम कोर्ट की. एक ये भी ऐसा इशू रेज हो रहा है हमारे अंदर, थोड़ी सी ये कमी रही है बिकॉज ऑफ एनी रीजन. we people are from the conservative side, especially accountant people like CA, CMA and CS. So we always have a conservative approach and we never thought of in our life कि हम IBC में आएंगे तो हमारे को इतने heavy disciplinary actions face करने पड़ेंगे. We are of the sober class. लेकिन अब हमारे सिर पे ये डंडा पड़ गया है. We need to unite together. We need to put a lot of petitions in the High Court. और जब तक हम लोग रोएंगे नहीं, अच्छी तरह से रोएंगे नहीं, but I assure you, we shall definitely get justice. That may take some time. जब हमारे साथ मदान सर, निपुण सर जैसे लीडर्स हैं जो हमारे को गाइड करने के लिए तैयार हैं, तो definitely we shall, get some results in the days to come also. No, if anyone would like to say anything else, please. Yes, please, Madan sir.
In the list of participants, I've seen the names of Mr. Sanjeev Ahuja, Mr. Madhusudan Sharma, and Ms. Poonam Shukla from IPA. If they can, if they want, certainly they should be given the opportunity to speak or say something.
Yes, please. Yes.
Yes, Madhusudan ji aaya. Madhusudan ji, please open your video also.
Yes, Madhusudan ji, please.
Madan ji, good afternoon to all. It was a very good discussion. I could join very late. And one thing which Mr. Gautam said, is the issue which I have been raising, because the idea behind putting IP entity as the IP is not in line with the spirit of the code, because the maximum focus is on the issue of honesty and integrity, which could be only for an individual. Because even if you see the discussion papers of IBBI earlier, they were talking about commercial entities cannot work professionally. So putting stress or putting focus on the IP entity to take the role of IP is a great deviation from the concept of putting IPs, individual persons as IPs. And that's, in my point, it's a very big change, which will affect the whole profession.
मधुसूदन जी, इसके contrary अगर हम लोग view देखें तो ये भी it also comes in the mind of regulator that how one person, one IP can manage a company of 10,000 crore rupees. If we have a comparison with IPE versus
The managing director is only a single person.
Manoj, you are venturing into a different
subject. Different, yes, sir. We should not
executive officer is a single individual. He controls the whole setup. And the best
we
would have been that IP
respect your
entities,
saying. We respect your saying.
Yeah, the IP entities should be only the service providers, and that will avoid the conflict of interest. The IP entity would not be able to take the assignments as IP. So then two parallel things can continue. Individuals need not invest resources in their firms, and they can really be independent, honest, and with integrity. Another set of people who have money.
Madhusudan ji, I think we are diverting from our topic. I'm sorry to stop you here. We respect your saying, and we respectfully saying this thing because today's topic is of DC.
So I gave my opinion. That's
Yeah, thank you very much. Thank you very much. Sir, Madan sir, aap please, Haji koi aur, Madhusudan ji, we are really thankful that you enlighten us. Anyone else would like to enlighten us further?
Mr. Dharmender Kumar is raising hand.
Dharmender Kumar ji, please unmute yourself.
Yes, sir. Thank you so much for giving opportunity. I just wanted to raise a question to Madan sir and to other advocates. There is a provision in the code. I don't remember exact section, sir, but all the acts of IP has been given protection under the code until there is a malified intention established by the law. So all bona fide action of the IP have been given protection under the code for CIRP. So I would like to have your views. If code is giving protection, how a regulation which is subordinate to code or the legislature intent of the legislature, how an IP without proving the malafide can be tried under regulation? So this is my basic question, sir.
Madan sir, I think he is referring to 233.
Yes, 233, yes. And 233 is a different ballgame. I filed number of applications under 233. I got the protection for insolvency professionals. In a recent case, the police authorities, one of the disgruntled, unsuccessful auction purchaser, he was not successful, so he filed a petition. Rather, actually, he defaulted in making the payment, and this liquidator, our insolvency brother, he forfeited the money. In consultation with SEC, he forfeited the money, and he went ahead with the new auction process. So this particular purchaser filed frivolous application and got an FIR registered against him and his wife also in one of the police stations. I went to NCLT, and the very first hearing got the protection for him under section 233. Because all these acts done by all these actions which were taken by the insolvency professional liquidator were well within the code. So
yes, sir. So my point is, when an IP is getting protection under other laws, why in the code itself that through subordinate legislation or subordinate regulation he is getting penalized, and section 233, as you said, the protection is given by the legislature in all other acts or this thing, but not in these regulations, subordinate regulations, sir.
These
So
are
I would like to have.
regulations, actions are being taken under the provisions of the code only, and those regulations have been drafted under the provisions of that particular sections. I think we need to take Dharmender, this is a separate issue. We can take it later on.
Okay, sir.
Because today it was confined to recent DC orders.
Mr. Manoj Singh, you would like to say something? I have unmuted you, please.
I think Manoj, it's time to close. I think the participants are leaving the forum.
Okay.
Already 5:10, yeah.
Yeah, it's already 5:11. And sir, thank you very much. Concluding remarks के अंदर मैं सिर्फ यही कहूँगा, if we club everything what we said, first of all, we should get united. Secondly, जो already affected हैं, they should not have any courtesy. They should go against all decisions of IBBI in the respective high court. Definitely, some justice will be there, especially when we have the guidance of both the advocates. You can contact Mr. Madan or Mr. Singhvi through us or individually at any time. Thank you very much. Thank you very much, Dharmender ji. Thank you very much, Ashok ji. Mr. Piyush Singh also was there. Thank you very much, Gautam ji. And with this note, I end my meeting. Thank you very much. Sir,
I'm so happy that I was not expecting that around 90 participants at one given point of time joined. Till the end of the program, around 70-75 were still there. Hats off to you.
Sir, yeah, hats off to you because you are our speaker. People came after seeing your name and Mr. Nipun Singh's name, and thank you very much. और मेरे को ये लग रहा है
circulated it in the southern.
I agree with Anand, sir. I agree with Anand ji.
Yeah, what I feel is that yeah, we are so motivated. हमने इस टॉपिक के ऊपर हम इसको शायद क्लोज नहीं करेंगे. हो सकता है अगर हमने इंटरनली बात करके और सर से भी बात करके we may have a part 2 of also it also because we understood broadly and we understood what we are supposed to do also. Let's have an internal discussion, then we come out with the conclusion or at least with the new topic. Thank you very much. Thank you, my all respected participants, which are still 54 at present. Thank you, my respected speakers. Thank you very much for enlightening us, guiding us. You are our friend, philosopher, and guide. Thank you very much.
Thank you, Madan sir. Very nice. Wonderful.
Thank you,
everybody. Thank you, especially Madan sir and Singhvi sir.
Thank you.
Thank you so much.
Very nicely.
Very well.
Let's have a series of discussion on these people.
Sure.
I think this is the most affected area, sir.
Manoj ji, please ask everybody to open their videos and have a group photograph. Screenshot lo.
Yes, sir.
Please do that.
ये मदान जी और निपुण जी का करिश्मा है कि इतने लोग जुड़ गए.
Yes, sir. Absolutely right, sir. Absolutely right.
और कहते मदान जी और निपुण जी जुड़ गए 1 और 1 11 हो गए. Sir, आप कहिए please carry on.
Kapil ji, you are expert in taking the screenshot. Please do that. Now, has anyone taken screenshot?
No, sir.
Yes, sir.
Yes, take it.
Okay, great. Thank you. Please share it.
Second also, you please take it.
Please share it. Thank you so much.
Thank you, Madan sir. Thank you, Madan sir.
Thank you so much.
Thank you, Bhupesh ji. हमने तो आपको बुलाया था भूपेश जी, आप गायब भी हो गए.
नहीं मैं यही था सर. I was just listening you. सारा सुन रहा था जी. Excellent deliberation sir. Thank you very much for the concern.
राजकुमार सरावगी जी कुछ नहीं बोले आज. राजकुमार सरावगी जी
अभी तक सफरिंग आई नहीं है. अभी तक कोई असाइनमेंट 4 साल से किया नहीं. इस कारण से हमने कहा चलो ठीक है छुट्टी.
सफरिंग कभी आएगी जब असाइनमेंट लोगे. असाइनमेंट लो, सफरिंग आ जाएगी.
एक असाइनमेंट अभी लिया है पर्सनल गारंटर का. ठीक है, देखते हैं.
But उसमें भी section 98 बड़ा खतरनाक है. जरा be watchful on that particular section 98.
Okay.
मुकेश मोहन जी हैं जो चले गए. प्रवीण जी आप कुछ कहना चाहेंगे? प्रवीण कुमार जैन, you are my co-host and please say something. I think thank you very much. Thanks a lot, everybody. Thank you very much. Thank you. I'm ending the session. Thank you very much.